is bad.
Yeah. Okay, let's see. Thank you. DeAndre Hill here. He is. He ran downstairs to put money in. Okay. Is Christopher Henson here? He is. State of Michigan versus Christopher Henson, 26-01621. Appearance, please.
Ross Marshall for the people.
You hear Christopher Henson? Okay, Mr. Henson, I believe I was going to treat today as another probable cause conference. You were trying to retain Mr. Blackman, correct?
Yeah, I talked to him last week. He said that he was going to meet with me midweek this week. I called him, didn't get an answer on Tuesday. Called him on Tuesday, didn't get an answer. I called his receptionist on Wednesday. She said that he is now gone until Monday.
Mr. Blackman was here yesterday, was he?
He was here, so I think he said that he was going to be leaving, so I think it's possible he's out of town.
Okay. Okay, so you've not spoken to him or to confirm that you're going to retain him?
And on him, yes.
I
Yeah.
understand that, but you had not yet had an opportunity to speak to him. Okay.
So, Your Honor, I think it's possible he anticipated that he wouldn't need an attorney, given that he was on the jail phone with the victim.
I'm sorry, what?
Well, he was on the phone at Lansing lockup telling the victim not to come to court, so I think it's possible he didn't think he would need an attorney. These calls were both before and after arraignment. He told her multiple times not to come to court, and I believe she actually picked him up from lockup after he bonded out. So I'm going to ask that he be remanded.
You believe he picked her?
Well, it sounded like her and his mother were both planning to go pick him up.
Oh.
I mean, they were talking about the case. He actually said at one point, I'm probably going to get in trouble for talking to you. I don't think he realized as much trouble he's going to get in because he's going to be charged with a felony count for witness against.
Okay. So the allegations are that you violated your bond conditions by having contact that was prohibited between you and Kristen Hippner. And so your bond violation or PA 53 violations are contempt of courts. When a court orders you not to have contact directly or indirectly, nor to cause anybody to have contact on your behalf, nor to be within 2,000 feet of wherever this person is, and then there's now an allegation of a violation or allegations of violations, you have the right to have a contested hearing because you're facing up to 93 days in jail for her violation. You understand that? You have the right to have an attorney represent you on those violations. If you're found to be in violations, again, that's something. You have a radio? You have a radio? I need security in here. He's being remanded.
We do have a detective assigned already to create a violation for.
Carlos was there when I walked through. Again, if you're found to be guilty, again, you're facing up to 93 days in jail plus up to $7,500 per violation. Are you requesting a public defender? You're not eligible, is what you're saying?
I lost my job. Yeah, this happened. They didn't know that, and they said I made too much money. That's why a public defender wouldn't see me.
But you have not been working since you were arraigned?
I worked like 4 days working with a buddy, just trying to do part-time work.
Okay, well then you can do a new intake with the public defender office so they can see if you're now eligible to be represented by their office. And so you are going to be remanded on the violations and the allegations of potential witness interference. Do you understand that? The witness is not here today, correct?
That is correct.
Let me get your new date for another probable cause conference and a bond violation hearing.
July 23rd at 9:30.
July 23rd at 9:30. Do you have any questions for the court? I can't hear you.
I'm just wondering why this is happening when my mom's the one that picked me up.
It's not just
I
about
can
being
play the
picked up.
calls if the court would like.
Do you want to hear the calls? It's not just about your mom picking you up. There's recorded phone calls, is the allegation of you violating a direct order of you not to have contact with this person and then telling them not to come to court, which is a felony. You understand now? Okay. You have any other questions? Okay. We'll see you on July 23rd. We'll send somebody down. I guess.
Thank you.
State of Michigan versus David Carter, 26-01635. Appearance, please.
Ross Martinez for the people.
Jacob Riley on behalf of Mr. Carter, who is present to my right.
Mr. Carter was present today for an examination of police officer pleading third degree. And my understanding is that there was going to be a waiver of preliminary examination. Is that accurate?
That is accurate.
Yes, Your Honor.
Was there an offer at all?
Yes, Your Honor. The people have offered that he would, for him to plead guilty to penal fourth degree. Currently he's charged under the motor vehicle code. The directive I received from Mr. Dwayne was to contact him directly if they wanted it amended to the penal code so that he could be eligible.
Okay. Mr. Riley, that's accurate.
As accurate, yes, sir.
Okay, Mr. Carter, do you understand that you have the right to have a preliminary examination on the felony charges? You understand at the time of the examination, you have the right to require the prosecution establish that they have sufficient probable cause of the felonies you've been charged with were committed and sufficient probable cause that you were the person who committed those felonies. You understand that? You wish to unconditionally waive your exam? You want to threaten me to do that? Sorry? You have to speak up because we have so many fans. Do you wish to unconditionally waive your examination? You want your exam? You gotta speak louder. Speak like you're in these streets.
Yes, Your Honor.
Thank you. Okay, and then anyone threatening you to get you to waive your exam? Okay, your bind over date is going to be the 22nd of July. That's the date the circuit court's going to receive this file, not a court date for you, okay? Your next court date will be a pre-trial. Your attorney will be made aware of that. What is your address?
1409 Eureka Street.
Speak louder.
1409 Eureka Street.
Speak louder.
1409.
You're using the same, you're not speaking louder.
I'm sorry, it is 1409 Eureka Street.
When did that become your address?
I'm about to leave back here with my mom.
When?
Like,
We're not turning down the fan now. He's gonna speak up because anytime you can catch felonies, I know you can speak louder than that. If we were outside and your homeboys was down the street, you wouldn't be talking at that level, would you? So why are you not speaking louder so that we can hear you? But I didn't ask you to use the inside voice. We can't hear you. The record has to be able to articulate what you're saying. Use your outside voice. Let me hear it. That's not your outside voice.
It's 1409.
That's not your outside voice.
It's 1409 Eureka Street.
Okay, when did you move there?
About like a week ago.
Okay, you understand that you have a responsibility under your bond conditions to notify the court in writing when you change your address?
I was gonna do it, I was doing part of the work, like trying to like get back there, to like pay all that, like do it. So like that is on my.
You're at FedEx?
Oh no, man, I ended up losing that job. I'm just at McDonald's right now.
You're at where?
McDonald's.
Okay. What's your phone number?
517-605-7764.
Okay. A bond was set at 5,000, 10%. That will continue. Any additional matters for the record?
Nothing for the people.
No, Your Honor.
You're all set. Let me see. Oh, there's Ms. Wanji. Sparks need to be brought up. This is Mr. Austin's client. Ms. Hill back? DeAndre Hill? State of Michigan versus DeAndre Hill, 26-01624. Appearance, please.
Ross Martinez for the people.
This was the date that was scheduled for a preliminary examination, but we said we would treat it as a probable cause conference because he was going to appeal the denial of a public defender. We do have an appearance now from the Office of the Public Defender this month, and you will be handling this case.
I was here.
Okay, and so we need to reset this for an exam.
Yes, Your Honor.
Yes, sir.
Okay, so you have the right to have your exam within 21 days of your arraignment, but due to you needing to appeal the denial, the court's gonna find good cause to go beyond the 21 days so that I can reset your matter, okay?
August 7th at 9:30.
August 7th at 9:30. Do you have any questions?
No.
Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for the defense, Your Honor.
You're all set. This is the state of Michigan versus Michael Green, 26-00905. Appearance, please.
Ross Martinez for the people.
Thank you, Your Honor, and good morning, Jared Austin, appearing on behalf of Mr. Green. He is currently in the jury box and is approaching council table.
Okay, Mr. Green was scheduled to have a preliminary examination. This is for delivery, manufacturing of drugs, police officer assault, and police officer cleaning and looting. How are we proceeding?
Your Honor, it's my understanding that Mr. Green wishes to conduct his exam.
My understanding as well, Your Honor.
Okay, witnesses are here.
Yes, Your Honor.
Okay. Alright, so, let me see, I think I just asked to have Sparks brought up. Is Sparks running the exam?
Sparks will be a waiver.
Okay, we'll handle Sparks and then we'll do his exam. But he can stay right there. We'll put Sparks in the jury box.
Well, that is out. Yeah.
Who represents Sparks?
I am, Your Honor.
Here's the paperwork.
Ms. Wanji.
Thanks.
How did we get here? Did they have the heat on? Huh? Is the heat on or the heat? I don't know. It was cold in Warwick when we had the meeting. So they show us, I don't know, maybe. What's gonna bring us up? Yes. Okay. On the record in the matter of the state of Michigan versus Martez Sparks, 26-01623, appearance please.
Ross Marchmead on behalf of the people filling in for Randall Behrman.
Good morning, Your Honor. And yet, Mr. Fox, who's by my side, the jury votes.
Mr. Sparks was here for several counts of controlled substance delivery manufacturing. There was a maintaining of a drug house as well. My understanding is there's an unconditional waiver of examination today.
That is correct, Your Honor. And we do have an offer placed on the record. It sounds like the defendant intends to accept the sort of report in which he would plead guilty only to count one. Counts 2, 3, and 4 would be dismissed. There would be an agreement to concurrent sentencing, and between now and the plea, there would be negotiations regarding the have notice and possible sentencing.
Is that completely accurate, Ms. Margie?
My understanding is that in exchange of us waiving the preliminary exam, the other counts are going to be dismissed.
The other counts other than count one?
Yes.
That is the agreement that we reached.
That's what it says.
I just want to clarify, we're not dismissing that dismissal will happen in the circuit court.
Correct.
That will happen.
And then the other information that he provided is also your understanding.
Yeah, the negotiations are continue. We will have a concurrent sentence, even though he's on bound, and it's discretionary that consecutive will happen.
Yes, that is correct. I do see that in Mr. Berman's email that there would be an agreement to concurrent sentencing. And the exact details of the sentencing agreement would be worked out in the circuit court.
Very good. Mr. Sparks, is there a reason why you're sitting down? Mr. Sparks, do you
Oh,
have?
yes, I couldn't hear, I'm sorry. I couldn't hear you. I don't hear.
Yeah, there's a lot of fans going too. I was asking, is there a reason why you're sitting down? I didn't know if there was an issue that you needed to sit.
I'm sitting down. This is bad.
Oh, okay. So you understand that you have the right to have a preliminary examination on these felonies?
Yes, I'm waiting.
Okay, and is anyone threatening you to waive your preliminary examinations?
No,
You understand the purpose of the preliminary examinations?
yes.
Okay, I find your waiver to be freely and voluntarily made. The bind over date is July 22nd. That's the date the circuit court's receiving these files, not the date that you need to appear in court, okay? Your next court date will be a pretrial. Ms. Wanji will be made aware of that. He's in custody for something other than this, correct?
Not in this county. He has a hold from Genesee County.
Okay. A bond was set at 10,000, 10%. That will continue. Any additional matters for the record?
Nothing from the people.
You know, we would like to bond people to celebrate. We would like Mr. Sparks to be able to go to Genesee County and take care of the matter that is already there. Because a good resolution on that case will also have an impact of what we're doing here.
What is the charge pending in Genesee County?
Same as the one here,
Oh.
position and to the legal.
Amend the bond to 10,000 personal recognizance. Any additional matters?
Nothing from the people.
Thank you.
You're all set. And we're gonna run that exam right now. Thank you. How many witnesses do you have for Green?
It's gonna be either 3 or 4.
Oh,
Then we're planning to run Buck as well.
Buck.
Yeah.
We'll leave Buck down there for now. What's going on with Williams?
Williams will be dismissal.
Mr. Austin, are you willing to waive his appearance?
Yes, I am.
Okay, well, we won't bring him up. A back on the record in the matter of the state of Michigan versus Michael Green, 26-00904.
Ross Marchvine on behalf of the people.
Thank you, Your Honor. Good morning. Jared Austin, appearing on behalf of Mr. Green, who appears with me at council table.
Mr. Green has a delivery manufacturing and police officer assault in meeting that we're ready to proceed on, correct?
That is correct, Your Honor.
Correct. Well,
Any preliminary matters before we call witnesses?
Yes, I will just note for the record that the people did extend an offer in this matter in which the defendant would plead guilty to count 1 as a third offense habitual offender with dismissal of counts 2 and 3. This offer will not be held open with the exam being conducted. It will be at the discretion of the circuit court attorney whether or not that offer wants to be reopened at some point.
And your client understands that, correct?
may I confirm with him again? He confirms to me that he does understand that, and it's my understanding he does not wish to avail himself of that offer. He wishes to run this hearing.
No other preliminary matters for the people.
Any for you?
I would just ask for an order of sequestration, Your Honor.
Sequestration is granted. You can call your witnesses.
People will first call Zachariah Vanderwood. Change of plan, calling Anthony Morgan.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth for the penalty of perjury. State your first and last name and spell both.
Andrew Morgan, ANDREWMORGAN.
You can proceed.
Trooper Morgan, how are you employed?
Commission Safeways.
And how long have you been so employed?
Just over 5 years.
And what is your current role at Michigan State Police?
Assigned to the Lansing Post as part of the Secured Cities Partnership.
And what sort of responsibilities do you have in the Lansing Post with the Secured Cities Partnership?
Investigating violent crime, gun crimes, drug crimes, and patrolling the greater Lansing area.
And were you working in that capacity on April 2nd, 2026?
Yes.
And at that time, were you asked to assist with some kind of a traffic stop?
Yes.
And what, just to understand your actions, what information were you given going into this?
Officer Vanderwerth let me know over the radio about a vehicle at, it was a gas station, I can't remember which one, that he observed an individual, Idris Woods, get into the passenger seat of of the vehicle, can give us the license plate of the vehicle.
And did you or anyone else you were with put that license plate number into the law enforcement information network?
Yes, Trooper Pauk, who was riding in the passenger seat, typed it into lean, and the return showed that the vehicle was EIV no, which means no insurance.
And did you personally see that it came back as no insurance?
Yes,
And did there come a time when you found this vehicle
yes,
and you confirmed that this matched the description and had the license plate that was given to you?
correct.
And did you attempt to initiate a traffic stop?
I did.
And at this time, were you in a marked police vehicle?
Yes, fully marked Michigan State Police patrol vehicle.
And when you initiated this stop, did you use your overhead lights?
Yes,
Did you activate the siren?
I can't remember if I activated this.
But you do remember activating your overhead lights?
Yes,
And where were you when you activated your lights? Y'all did the car. I put it as a bad question. When you activated your overhead lights, how close were you to the suspect?
definitely like close enough for them to see. I wouldn't say it was like as close as typical because the vehicle was already speeding away, basically.
And what happened when you activated your lights?
The vehicle continued speeding away at a high rate of speed on the side street.
And was the vehicle accelerating?
Yes,
And when you say side street, what do you mean by that?
it wasn't a main road like in the city of Lansing. I would consider like MLK, Cedar, Pennsylvania is like a main road. It was a side street off of Pleasant Grove Road.
Was it in like a residential area?
Yes,
So there were houses on either side of the street?
yes,
And did the vehicle appear to be exceeding the speed limit?
yes.
And did you attempt to pursue the vehicle?
No, not to the vehicle. I believe I pulled over to the side of the road.
Now, briefly, could you, I don't think I asked this, describe kind of what the vehicle looked like?
It's a red Buick SUV crossover type vehicle, small SUV.
And at the time you activated your lights and the vehicle accelerated away, were you in the city of Lansing?
Correct.
And were you in Union County?
Correct.
Now, were you eventually given information about this vehicle or the driver of the vehicle being located?
Yes.
What information were you given?
That the vehicle is located on Cooper Street, where we know that Idris Woods has ties to. So units were already heading over there because we figured if he was in the vehicle, that was a place for it to go. And I was given information that the vehicle was located on Cooper Street, and then that the driver of the vehicle had ran into a backyard and jumped over it.
And did you eventually find the person who was the driver of the vehicle?
Officer Backery found him, and I came up behind him basically as he was taking him into custody.
So you arrived at this Cooper Street location as he was being taken into custody by Officer Proctor, is that what you were saying?
Correct, but several backyards down the street from the vehicle after he ran.
And did you eventually approach the officer and the person who was being arrested?
I did.
And did you see anything unusual in the vicinity of this person?
I saw drugs laying on the ground next to him.
Okay, and when you say drugs, can you just tell me what you saw that made you believe you were looking at drugs?
I believe it was packaged in a Ziploc bag. I believe it was, I didn't look at it super closely. It was a bunch of individual packages within a Ziploc bag.
So there was a large Ziploc, there's a Ziploc bag, and then inside of the Ziploc bag, there were smaller packages.
From what I remember, yes.
And do you have training and experience in, I guess, drug deals and drug transactions?
Oh, a little bit, yeah.
And in your no, I'll just confess that. Now, and you said, was it one bag or two bags?
I think it was just one.
And did you then, What did you do with this evidence? When you were-
I turned it over to Officer Vanderwood.
And the person who they were arresting, do you see him in the room right now? Could you please tell me where he's sitting and describe his clothing?
Sitting to my left in a blue jumpsuit.
Your Honor, could the record reflect the witness has identified the defendant?
Any objection?
Without objection.
So noted.
Now, at the time you saw the what you believe to be drugs on the ground, how close were the drugs to the defendant?
Within arm's length, I would say.
And did it appear as though other officers had been, I guess, struggling with the defendant? Couldn't tell. Okay. And was there anyone else in the vicinity who was not a police officer?
No.
And you may have already answered. Did you say that you gave the drugs to a different officer?
Yes, Officer Vanderwood.
All right, that's all the questions I have.
Can you give me the address? Did you say it was Pleasant Grove, or where did this take place originally?
The traffic stop?
Yes.
I think it was on Radford Street,
Rad-
just off of Pleasant Grove in the neighborhood.
Okay, thank you.
Yes.
The prosecutor.
Morning, Trooper.
Good morning, sir.
So, as I understand it correctly, you were originally given some information about a vehicle at a gas station. Is that correct?
Correct.
Okay. And that vehicle concerned an Idris Woods.
That was the original concern, I guess.
And were you given any particular type of directive as to what you were supposed to do with this information? Were you told to run the plate information, follow the vehicle, attempt to stop the vehicle, anything like that?
I was told to do anything.
Was there any other information passed along to you regarding that vehicle outside of what you've already told us as to the location that Mr. Woods was in that vehicle and the license plate number?
No, just a continuous, after it left the gas station until I attempted to conduct a traffic stop, the continuous location of the vehicle where it was driving.
And it's your testimony that you initiated a traffic stop based upon the information that you came across after running the license plate. Is that correct?
Correct.
And at some point you saw or came into eyesight of this particular vehicle. Is that right?
Yes,
Is that when you're saying that it was traveling at a high rate of speed?
correct. It turned off of Pleasant Grove onto Radford Street at what I would say is already a high rate of speed for residential.
Was it doing that before or after you initiated your overhead lights?
It was doing it before and then worse after.
And at any point were you able to determine what speed the vehicle was going? Were you using any type of radar or anything like that?
No radar.
And was there anyone else that you were working with in your vehicle, your patrol vehicle, or is it just you?
The pop was my passenger in my patrol vehicle.
And how long, I guess, after you had tried to initiate the traffic stop, did you terminate that particular pursuit?
I would say half a block, like what would be a normal downtown block area.
Relatively short amount of time, in other words?
Yes.
Okay. And what period of passage of time are we talking about between when you terminated that particular suit and then you came across who you said was Mr. Green on the ground phone?
For that time, by less than 10 minutes, I would say.
And when you saw the vehicle and you attempted to initiate a stop of the vehicle, were you able to see who was driving the vehicle?
No.
Were you able to see or determine how many people were in the vehicle?
No.
And as far as you can recall, the ownership of that vehicle was not traced back to Mr. Green, is that correct?
Correct.
And you were asked some questions about drugs and I believe you said baggies on the ground in some proximity to Mr. Green, is that correct?
Correct.
And you did not see or witness Mr. Green discard those to the ground, is that correct?
That's correct.
You did not see those fall from this person, is that correct?
Correct.
And you did not personally see or observe how or when those baggies of drugs got there, is that correct?
Correct.
And other than Mr. Green and law enforcement, you did not see anyone else around that particular scene, am I understanding that correctly? Sure. Thank you.
Derek?
Okay, we're gonna talk a little bit about what happened with this vehicle when you activated your overhead lights, okay? So just to clarify, you indicated it was already moving at a high rate of speed at the time you activated the lights.
Correct.
And was there any change in the behavior of the vehicle after your overhead lights were activated?
I accelerated. I don't remember if it weaved into the other lane or anything like that, but it accelerated away.
And that was that immediately after you activated your overhead lights?
Yes.
No further questions. Thank you.
May Triple Morgan be excused?
Yes, Your Honor.
Thank you, may be excused.
Okay, this time we are calling Zachariah Van.
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Can you state your first and last name and spell both?
Yes. Officer Zachariah Vanderwerf, first name is spelled Zachariah. Last name is Vanderwerf, that's Vanderwerf.
Officer Vanderwerf, how are you employed?
With the City of Lansing Police Department.
What is your role at the City of Lansing Police Department?
I currently work with our DCI team.
DCI, what is that?
It's a violent crime initiative.
And is that partnered with any other police agencies?
Yes, with Michigan State Police.
And would that be with the Secured Cities Partnership?
Yes.
Now, were you working in that capacity on, I didn't ask you, what does that entail? I apologize, getting ahead of myself.
So basically our goal is to help reduce violent crime in the city.
And what do you personally do as an officer with this group?
So my job function is I usually am riding around in an unmarked police vehicle. Usually that entails us being in plain clothes. We wear like a tactical vest over our clothes that have police markings on the front and back.
Were you working in that capacity on April 2nd, 2026?
Yes.
And did you find yourself did you find yourself at 1826 South Cedar Street on that day?
Yes.
And what is that location?
So that's a Cedar Super Liquor Store.
And what were you doing at this location?
So I was conducting surveillance of the liquor store. I observed a red Buick SUV that was pulled up at the gas pumps. And then on the passenger side of the vehicle, I observed a subject that I know that I could positively identify as Idris Woods. I recognized him from a recent SOS drug raid on March, would have been March 4th, is when we dealt with him. When we did that raid, he was somebody I had contact with inside the home. I found narcotics on his person, and there was firearms that were located during the search warrant.
And when indicated this person was in the passenger seat.
I saw him on the passenger side of the vehicle. When the vehicle left, he ends up getting into the passenger side of the vehicle.
And did you see the vehicle when it arrived?
I did not see it when it initially arrived, no. I only saw it parked at the pumps.
So you saw it at the pumps and then you saw it leave.
Yes,
And did you see the person who was driving the car?
yes,
And at that point in time, did you know who this person was?
I did not.
But did you observe any, I guess, recognizable clothing that he was wearing?
Yes, he was wearing like a red and blue jacket. It was pretty identifiable. I believe it was later discovered to be like a Phillies jacket.
But at that time, you just saw it was a distinct red and blue jacket.
Yes,
And were you able to see the license plate on this vehicle?
yes,
And at this time, were you in an unmarked vehicle?
yes,
And did you put this license plate into the law enforcement information network?
yes,
And did you receive any noteworthy information?
yes. It said the EIV was no, which is the electronic insurance verification, which just means it doesn't have insurance on it.
What did you do with this information?
I can't recall if I ended up radioing that information over to the MSP troopers. But I was kind of just there by myself waiting until they completed a separate traffic stop.
Did you attempt to continue surveillance as the vehicle left the gas station liquor store?
Yes,
Were you able to continue your surveillance, or did there come a time when you lost your vehicle?
I did lose view of it, but I was able to maintain surveillance on the vehicle until King and Olds was the street, and then I lost sight of it.
Now, did you eventually receive information regarding the ultimate location of this vehicle?
Yes, Officer Phil Warren ended up radioing that he located the vehicle.
And do you recall where this vehicle was located?
I do not remember that.
But did you eventually go to where the vehicle was?
Yes,
And taking a step back, the observations you're making at this liquor store, was that in the city of Lansing?
yes,
And was it in the county?
yes.
Now, did you write, if you were to look at your police report, might that refresh your memory of where the vehicle was located?
Yes.
Showing defense table the police report. Your Honor, may I approach the witness?
Yes.
Just let me know if this refreshes your memory.
Yes.
And where was the vehicle located?
6310 Cooper Road.
Is that in the city of Lansing?
Yes,
And is that in Lynn County?
yes,
Were you given information suggesting that there might be cause to search the vehicle?
yes.
And what information were you given?
So I was told that there was narcotics that were found in close proximity where Mr. Green was arrested.
And did you assist in a search of this vehicle?
Yes,
And did you find anything of note?
Officer Ellis located a digital scale, which I eventually collected as evidence, and then I collected 2 phones from inside of the car.
So you
You collected what?
2 phones.
So you collected two phones, and you did personally observe this digital scale.
Yes,
And were you the 2 phones, digital scale? Was there anything else of note found in the vehicle?
not that I recall.
Now, when you arrived at the vehicle, did you come to see the person who had been driving it?
I don't recall if I did or not. I believe when he was arrested that I eventually made my way over there to where he was located and arrested.
Moving past that, were you, I'm sorry if I already asked this, it's Friday and it's very hot, were you given any evidence that someone else collected?
Yes,
And what were you given?
I was given non-narcotics, which was believed to be suspected narcotics.
And can you sort of describe the packaging of these narcotics?
They were in plastic baggies.
Um, when you say plastic baggies, were they like Ziploc type bags, something like that?
No, I don't believe it was Ziploc bags.
How many bags? Were there?
2.
And were there, was it just loose in these 2 bags, or were there separate packaging of them?
I don't believe they were separate packaging. I think it was just loose in the bags.
And did you conduct, can you explain a little bit what a true narc test is?
So basically, we'll just use a true narc test that will essentially just test the narcotics for us. So we'll do like self checks as an example. You do a self check on the true narc to make sure that it's functioning properly. And then what you'll do is you'll hold it over the suspected narcotics. You'll run the test on it. It'll tell you what it is, and then you'll run a self check test after to make sure that it functions properly.
And did you ultimately follow that procedure and conduct tests on the substances in these bags?
Yes.
And what were the results of these tests?
So for the narcotic that was white in color, that came back to cocaine base for the true narc test, and then the other came back as fentanyl compound.
And let's start with the cocaine base. What was the weight of this cocaine?
12 grams.
And then the fentanyl compound, how much was that?
4 grams.
Okay, so total 16 grams, 12 cocaine base, 4 fentanyl compound.
Yes.
Now, do you have knowledge of the person? Well, actually, take a step back. Did you eventually view any sort of surveillance footage that might have given you information of who was driving this car?
Yes.
Where did you obtain this surveillance footage?
So I went to the Cedar Super Liquor Store and I made contact with an employee there, and he showed me a video of them, Mr. Green pulling up to the pumps, pumping gas, and then leaving in that car.
And you say Mr. Green are referring to the person who you observed in the distinctive jacket?
Yes.
And then did there come a time when, did you receive information that Mr. Green had been taken to the hospital?
Yes.
And did you eventually make contact with him at the hospital?
Yes, I did.
And to your knowledge, was anything of note found on his person at the hospital?
They found a large sum of money. So it was like, I think that totaled out to $1,264.
Your Honor, gonna object to lack of foundation. At this point, it's unclear whether or not the officer is testifying on his own personal knowledge or what someone told him.
Did you personally collect this money, or were you told that the money was collected?
I collected this money personally, but I believe the officer that located it was Trooper Paul, the one that located the money.
So you did not personally see the money on him, but you were given the money you signed.
Yes.
And did you speak with Mr. Green about this money?
Yes, I did.
And did he acknowledge that it was his?
Yes.
Okay. And did you ask him if he was employed?
I did.
And what did he tell you?
I don't recall the exact specifics, but I believe he told me that he just got a job at the state of Michigan.
Okay. And did you ask him if he had been paid yet by that job?
Yes.
What did he tell you?
No.
So he told you no, he had not yet been paid.
No.
And did you ask him about how he got this large, more than $1,200 in cash that he had?
I don't recall.
Now, if you were to look at your police report, would that refresh your memory as to whether you asked him if he, how he got the money?
Yes.
Right, I'm once again showing Defense Table B police report. Your Honor, may I again approach the witness? That's good. Approaching the witness with his police report. Now, again, just take a look and then let me know whether yes or no if it refreshes your memory.
Yes.
And did you ask him where he got the money?
Yes.
And what did he tell you?
He was unable to answer the question.
One second. Now, you indicated you're part of the Violent Crime Initiative. Do you have training experience regarding, I guess, drugs and drug transactions?
I don't know if it's specifically from BCI, just probably my training experience in being a police officer for the last 9 years.
So over the 9 years, do you have experience dealing with drugs and drug transactions?
Yes.
How much experience would you say that you have? If you could just explain it.
I don't know. I don't know if I can quantify it that specifically, but I have arrested people for drugs and narcotics. I have seized money before. So
And from your experience, is it common for people who are arresting in connection with drug transactions to have large amounts of cash?
Your Honor, I'm just going to object. I don't think there's been sufficient foundation for the witness to give this particular type of opinion test.
Well, I'm not asking for his opinion. I'm just asking for his experience and whether this is consistent with things that have happened.
And you're asking about
Yeah,
his
I'm not
experience in his
asking-
previous arrest that involved drugs. You can speak to previous experience, objections overruled.
In your previous experience making arrests involving drug transactions, is it common for people to have large amounts of cash?
no,
Now, in your experience involving drug transactions and drug sales, is it the amount of drugs, is that something that is normal for personal consumption in your experience?
in my experience, typically it'll be smaller amounts than what we located.
And I don't have any further questions. Thank you.
Prosecute.
Morning, officer.
Good morning.
So you started out your testimony saying that you were conducting surveillance of liquor store, is that right?
Yes.
And why was it that you were doing that?
It's honestly, it's something as part of BCI we typically do. It's something where we'll spend time at liquor stores or gas stations and we'll conduct surveillance.
And is that something someone in particular directed you to do on this particular date and time to make that decision yourself, or how did it come to be that you were conducting surveillance at this particular liquor store?
I made that decision myself.
And you indicated, I believe, that you had recognized and had some prior experience with one of the occupants of the vehicle, Mr. Peterson. Is that correct?
Yes.
And you've had previous experience with him as it related to, I believe you said, drugs and guns, you said. Is that
Yes.
correct?
Yes.
And I did not hear you say that you've had any such previous experience of drugs, for example, with Mr. Green. Is that true?
That's true.
And you did not know, or you were unfamiliar with Mr. Green until this particular night?
True.
You were not surveilling or particularly looking for Mr. Green for anything in particular, is that correct?
That's correct.
And at some point you ended up running the information from the license plate on that vehicle, is that correct?
Yes.
That's when you said that you had learned that it indicated it didn't have insurance or something like that, is that right?
Correct.
And the ownership of that vehicle did not come traced back to Mr. Green in any way, is that right?
I don't recall, but I don't believe it registered back.
And at some point later during this or later in your investigation, you were able to see some footage from the liquor store involving this vehicle, is that correct?
Yes.
Okay. And I believe it. And from your observations of that video, the vehicle would have arrived some around 2019 hours, is that correct?
Yes.
Is that 8:19 p.m.?
Yes.
Okay. And the vehicle left about 7 minutes later, around 8:26.
Trying to remember from my report, but I don't recall exact time it left.
If your report indicated that you saw from the video that it was leaving at 12:26 hours, 7 minutes later, would you have any reason to dispute that?
No, I wouldn't have any reason to dispute that.
Okay. So when the vehicle leaves the store, leaves the liquor store, did you have any immediate pursuit of that vehicle?
No,
So there was a passage of time between when you would have observed the vehicle leaving the liquor store until the next time you came upon the vehicle then, is that correct?
so I was still able to maintain sight of where I was on the vehicle as it was leaving and as it was going down Mount Hope.
And so the vehicle was going down Mount Hope.
Yes,
Was that immediately after it left the liquor store?
yes.
Okay. When's the next time you saw the vehicle?
The last place I had observed it was King and Olds.
And what passage of time are we talking about when you saw the vehicle there between when you last lost sight of it on Mount Hope?
I'm not sure what the time would be.
Do you know if it would be 5 minutes, 10 minutes, more or less?
I don't know. I don't know how long that's the time of that.
But it's safe to say there was some type of passage of time then. Is that fair to say?
Yeah.
Okay. And whatever that passage of time is, you can't recall what it is, but whatever that passage of time is, it's fair to say you don't know what was happening with that vehicle or inside that vehicle during that time that you did not observe the vehicle. Is that true?
True.
Okay. You would have no idea what stops, if any, the vehicle would have made during that period of time that you didn't have sight of.
Correct.
You have no idea if the driver would have been the same during that passage of time that you did not have sight of the vehicle. Is that correct?
That's correct.
And were you the one that personally administered the True Narc test?
Yes.
Is that something you're trained to do?
Yes.
And what type of training is required for that?
I just received, I think it was like a day's worth of training for it.
When was that? You recall?
Oh, no, it was a while ago.
Is that something that requires any type of continuing training, or do you have to do something to renew a certificate or anything like that?
I don't know the answer to that question. I don't know if it does.
You know anything about the maintenance of that particular device?
I do not.
Okay. Say then that that's not something that you personally do, that you don't maintain it or calibrate it, assuming that such things do happen to that device.
Sure.
And I want to talk a little bit about your experience as it relates to drug arrests or perhaps drug trafficking arrests. You were questioned about a moment ago. Okay. And are you able to gauge what percentage of your investigations or arrests involve drugs or drug trafficking?
I wouldn't know that.
It's safe to say the majority of what you do does not involve drug arrests or drug trafficking arrests.
Yeah.
Okay. And do you have any particularized training as it relates to drug offenses or drug trafficking offenses?
No.
And have you ever been a part of Tri-County Metro, for example, which I believe focuses mainly on drugs and drugs trafficking?
Maybe not specifically Tri-County Metro. I know we've assisted them with search warrants before, but more often than not, we would have more experience dealing with like our SOS team.
But you have never been a part of Tri-County Metro, is that correct?
No, I haven't.
And your involvement with them would be assisting them in executing warrants and so forth?
Yes.
And your involvement does not involve helping them investigate such matters on drugs or drug trafficking?
No.
And you're asking questions about the weight of the two substances that we've been talking about here. And correct me if I'm wrong, but I believe it was your testimony is that would be inconsistent with personal use or possession. Was I understanding your testimony correctly?
Yes, based on my experience.
Okay. And tell us about that experience of each of you, all that.
Just from my experience, typically if we're getting someone for like possession amount, it's like a gram or 2 grams, if that, sometimes less. So it's not as high as 16.
And is there a particular cutoff that you're looking for that causes you to distinguish between the two when you think it's mere possession versus possible possession with intent to distribute?
I would say I think that can vary because I mean, if you have a smaller amount, then maybe there's some other things like large sums of money, or you have it individually packaged, or if you do have a digital scale on you, I think those are all factors that would potentially change that.
And the fentanyl compound that you talked about, that was approximately 4 grams, is that correct?
Yes.
You're saying you believe that 4 grams would be inconsistent with someone possessing it for their mere personal use?
Not necessarily.
So in other words, that could be an amount that could be consistent with that?
It could be.
And you talked about a scale, I believe, being found that was in the vehicle, is that correct?
Yes.
Again, that was a vehicle that Mr. Woods was in,
Yes.
and a vehicle that was not owned, as far as you're aware, by Mr.
Correct.
And you talked about 2 phones that were found, is that correct?
Yes,
Were those in the vehicle as well?
they were.
Were you able to trace those phones back to Mr. Green and anyone?
No, I don't even know if there's been anything done with those phones.
And safe to say that though you did not see those phones come from Mr. Green's person first, was that correct?
That's right.
And when speaking with Mr. Green, he did not take ownership of those phones, is that correct?
Never took ownership of the phones when I was with them.
And you were speaking with Mr. Green when he was in the hospital, is that right?
That's right.
You know what he was taken to the hospital for?
I believe it was a taser deployment, but I don't know that for sure.
So you believe what?
Taser deployment,
Oh,
I believe.
And you know if Mr. Green had been administered any type of medications prior to you speaking with him?
I don't know if he was or not.
You said Mr. Green acknowledged that he had a job or recently started a job, is that correct?
Correct.
And he certainly never made any admissions that any cash he had on him was from any type of illegal activity, is that correct?
That's correct.
I think it's all the questions.
No redirects.
Officer Vanderer.
Thank you.
Call your next witness.
People now call Jamil Bakri.
So Jamil Bakri.
Yes.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can have a seat. State your first and last name is formal.
Jamal Bakri, Jameil. Last name B as in boy, Akri.
Officer Bakri, how are you employed?
The city of Lansing,
What is your role with the city of Lansing?
police officer,
And how long have you been a police officer with the city of Lansing?
approximately 7 years.
And what is your role with Lansing Police?
Currently, I work on the violent crime initiative, so VCI.
What kind of responsibilities do you have?
It's a multi-jurisdictional team that is aimed at curbing violent crime in the greater Lansing area.
Were you working in that capacity on April 2nd, 2026?
I will.
And on that date, were you requested to give any sort of assistance?
Yes.
What was the nature of this request?
MSG, who we work closely with, advised that they were conducting a traffic stop via radio, and that vehicle that they were conducting a traffic stop on as well.
And MSP, does that stand for Michigan State Police?
Yes, sir.
As in the state of Michigan, not the university.
Yeah.
And were you given a description of this vehicle and or a direction where it could be going, could be found?
Yeah, via radio. It was a red Buick SUV, and it was last seen going eastbound.
And did you take any steps to try and locate this vehicle?
I did.
And what did you do?
I drove eastbound on Miller. Ultimately, it was located by another officer that was on this.
And were you given any information about the driver of this vehicle?
When the vehicle was located via radio, I heard that there was a subject running westbound from Cooper Road, which is where the vehicle was from.
And after you received word that someone was fleeing on foot, what, if any, steps did you take to try and locate this person?
Recognizing that Washington, or South Washington, is directly to the west, I went to the west. I had heard via radio that other officers had located the subject to the west, and that he was now running back eastbound, back towards Cooper Road. Recognizing I was already on Washington, I drove to, I think it was 6421. They've got a long driveway and a really open backyard. I drove my car back there so that I could, it was nighttime, so I could illuminate the backyard with my headlights and see.
And so then you were trying to illuminate like the backyards of nearby houses?
Yes, so the officers via radio advised that it was in the 6400 block that the subject ran back eastbound from, I guess it would be Washington. So I was at 6421 and drove to the backyard. But all the backyards are fenced in, but it's chain link fence. So in order to see, I guess, better back there.
And did you see anything noteworthy?
I did.
What did you see?
The description that we'd been given was there was a black male wearing a red jacket that had ran from the west and then back to the east. And upon lighting up the backyard, I saw a black male wearing a red jacket standing on the southwest corner of, it would be 6424 Cooper Road. But it's the backyard that's directly east of 6421 South Washington that I was in.
And at this time, were you in, can you just describe sort of the vehicle you were using and how you were dressed?
Yes, so VCI, we work in an unmarked capacity. So my vehicle was a plain everyday vehicle. There's no police markings on that vehicle. However, my clothing is, I wear a outer carrier vest that has large police letters on the front, as well as a large police bag in the back.
And did you approach the suspect?
I did.
And did you identify yourself as police?
I stated stop. So at this moment in time, there was multiple marked patrol vehicles surrounding the area to the west and to the east. I advised them to stop and start to move away.
So there were police vehicles in the area and you told him to stop.
Correct. So there was police vehicles on Washington. Those were fully marked patrol vehicles. And then there was also, to my knowledge, was police vehicles to the east.
And you were wearing something that on the front said police.
Correct.
And was there any light that could have illuminated it so that you could see that you were wearing a police best to recall?
I can't recall if there was light at that moment in time behind me. I think at that time I'd gotten out of my vehicle, which would have turned off the lights to the vehicle. But he looked straight towards me as I stated and then responded by moving away.
Okay, so he looked at you and you told him to stop, and then after seeing you and hearing stop, that's when he turned away.
So when I said, once I jumped the fence and was in the backyard that he was in, which would again be the backyard 6424, I yelled, stop. And then he looked towards me and then started to walk. Basically, because I was running southeast towards the house at an angle. So he walked further east along that residence. Based on the angle that I was running at, I lost visual of him because I'm walking, I guess, by the house.
And did you eventually catch up to him?
I did. As I got closer, I yelled, police, or I yelled, stop, you're gonna get tased. At that moment in time, there was light. We were now towards the Cooper Road side. And he, again, disregarded my request. I attempted to utilize my taser 2 separate times, but due to the clothing that the subject was wearing, I wasn't able to, it didn't penetrate, so it didn't work.
So you deployed the taser, but were not successful in incapacitating him.
Sure.
And at this point in time, was he attempting to climb into the fences or anything like
Yes,
that?
he was. At this moment in time, he had moved towards the fence that lined the south side of the property of 6424 Cooper Road. And he was grabbing onto the top of the fence. And in my experience, that was indicative of the subject who was getting ready to jump the fence. So I quickly disregarded my taser and grabbed on him to stop his further flight.
And what happened after you grabbed on?
After grabbing onto him, I pulled on him to rip his grip from the top of the top bar of the fence, and then pulled him to the ground.
And at this point, did he become cooperative?
No. So another officer who had gotten into the backyard with me had grabbed onto his left hand. His right arm was still under his body, and I had to physically pull his arm out in order to put it behind his back.
And then at this point, were you able to cuff him and apprehend him?
At this point in time, he was.
And did you speak with him at all?
I did.
And did he give any indication of knowledge that he was, I guess, running from police?
Yes.
What did he say to you about that?
He stated that he had a warrant, and that's what he was running.
So he acknowledged that he was running away from the police.
Sure.
And at the time that you made contact with him in the backyard, was there anyone else around you that was not police?
No.
And the person who you stopped and who you had this interaction with, you see in the courtroom right now.
I do.
Could you please tell me where he's sitting and describe his clothing?
Yeah, he's sitting off to my left, he's wearing a navy blue shirt.
Your Honor, for the record reflects the minutes identified the defendant.
Objection.
Without objection.
So noted.
And the yard where you had this interaction, do you recall the address?
6424 Cooper Road.
Is that in the city of Lansing County?
It is.
I have no further questions for this.
Cross-examination.
Good morning, officer.
Morning, sir.
So you were essentially assisting or asked to assist as it related to this particular vehicle. Is that correct?
Correct. We work alongside MSP, and they made a traffic stop in the vehicle fled. So after that, I drove over there to assist.
Okay. And the pursuit of this vehicle, that was already ongoing when your involvement began, is that right?
I'm not sure that they pursued it. I think we actually lost the vehicle for a small amount of time before it was located.
And did you ever witness the vehicle driving or in motion yourself?
I did not.
Okay. So it's safe to say you did not witness who was driving the vehicle, is that correct?
I did not witness it.
Okay. And you did not see who would have exited from the driver's side of that vehicle?
I did not see that.
talked about encountering Mr. Green, and it sounds like you're saying there were multiple either law enforcement agencies or law enforcement officers there at that time. Is that correct?
In the surrounding area, yes.
Okay. Other than law enforcement and Mr. Green, was anyone else there?
In regards to the backyard that we were in,
Yes, or anyone that you knew or believed to be connected with the car other than Mr.
there was another subject that was outstanding that was said to have been inside the vehicle that at that moment in time. That what I was reacting off of was the officers saying that they had seen a subject run, and that other officers from the other side saying and describing the subject that they saw run back.
And this other subject that you were talking about, was that a male subject or a female subject? Do you know?
It was a male subject.
He was not on scene where Mr. Green was when we were there. Is that correct?
Correct.
So the question.
Can you redirect?
Now you, during your initial testimony, gave a description of the jacket that the subject was wearing. Did that match the description that you were given on the radio dispatch?
Yes.
No further questions.
You may be excused. Thank you.
I'm going to go check the witness room if that's okay. Right, this time people rest.
Witnesses from the defense today.
We'll rely on the evidence presented, Your Honor. Thank you.
Proceed to argument.
Okay. We currently have three felony counts as of now. Unfortunately, I don't believe I'm going to be able to request bind over on count one. We did not have all the witnesses that we needed to tie everything together to establish the intent to distribute. Sometimes that's just how it goes. We are going to seek to add a count four, which is just a simple possession rather than possession with intent to distribute. So I'll just start in order. So we'll discuss count one. I considered requesting a continuance. There's a 180-day case. Yeah, that's just how things felt today. So count two is resisting or obstructing a police officer. We certainly have evidence of the resistance. We have disobeying lawful commands by continuing to flee, and then we have physical resistance by needing to be taken off of the fence, and then there was some struggling on the ground. We have established lawful commands, given that there is probable cause to believe that he had been fleeing from police. And as far as identifying himself as a police officer, of course, he's not in a uniform, but he is wearing a vest that clearly marked police. There's police in the area. As we'll discuss in count three, there's reason to believe that he had just been fleeing from the police. So he's yelling, "You're going to get tased," stuff like that. I think that minimum on a probable cause basis, we have reason. We've established that this is a police officer lawfully performing doing duties, and he's failing to comply with lawful commands, and he is physically resisting. Now, as far as count three, fingerling a police officer, we of course had testimony from Trooper Morgan, indicating there's a lawful basis for a traffic stop, in that the vehicle did not have any insurance. We had testimony that he's in a marked vehicle and activated his overhead light, and that immediately upon the overhead light being activated, the vehicle sped up in what certainly seemed to be an attempt to evade capture, to evade the stop being initiated by Trooper Morgan. And as far as establishing that this defendant was the driver of the vehicle, that's sort of pieced together. We have testimony from Officer Vanderwerf indicating that there was this other person in the passenger seat, but described seeing someone in this distinctive jacket getting into the vehicle. And then we, of course, later have Officer Vanderwerf identifying this person as, speaking with him in the hospital. He's in the hospital, indicating a taser deployment. We have testimony from Officer Fockbury that he deployed the taser on this individual, and he was found in the vicinity of this red car with this license plate. And we did have further confirmation from Officer Vanderwerf that we saw surveillance footage that included the person in the jacket getting into the vehicle and driving away. So we do have probable cause to believe that this defendant is the person who was driving away from in the vehicle at the time that it fled from police. Then the people will seek to add count 4, possession of cocaine less than 50 grams, and we'll be going for somewhat of a constructive possession approach, I suppose. We have these bags. Officer, Trooper Morgan indicated it was 1 bag, and Officer Vanderwerf indicated 2 bags. But regardless, we have, it seems like Trooper Morgan's memory of the exact nature of the drugs is not terrific, but we have testimony that he found these drugs and gave it to Officer Vanderwerf. Officer Vanderwerf, we established that they were controlled substance via this TrueNarc test. And as far as attributing this to the defendant, Trooper Morgan, of course, identified the defendant and described it being within, I believe he said, within arm's reach of the defendant. The only other people around were police officers, and I think we can use our common sense to infer that the police were not carrying around bags of drugs. And I think we can also infer that it could have fallen off of his person during this struggle with police, in which he pulled off the fence and taken to the ground. So from all of that, we can infer that he was in possession of his drugs. And so then some of the people are going to request dismissal of count 1, fine over on count 2, resisting or obstructing a police officer, fine over on count 3, fleeing or eluding a police officer, and move 4-3 under the penal code, and then an added count for possession of cocaine. Thank you.
Thank you, Your Honor. Ultimately, we're going to be opposing the bind over. I'm going to be addressing people's motion on these counts a little bit out of order. I think I'm going to start first with the fleeing and eluding. I think there's an important distinction here from the testimony that I would like to bring to the court's decision when it makes its decision for whether or not Mr. Green was driving the vehicle when it was attempting to be stopped by law enforcement. The testimony we had is it sounds like that there was testimony and evidence that Mr. Green at some point earlier had been driving the vehicle, but one of the consistencies, one of the couple of consistencies I think among the testimony was that there was some passage of time between when Mr. Green would have been observed on the driver's side of the vehicle at the liquor store and when it was the traffic stop was trying to be initiated or the vehicle eventually did stop and at some point Mr. Green got out of the vehicle. The question is, was Mr. Green driving the vehicle at some point during this interaction? Was he driving the vehicle when it was attempting to be pulled over by law enforcement? And I believe the testimony from all the witnesses was they could not see or identify who was driving the vehicle at the points that the vehicle was trying to be pulled over.
Are you talking about after the vehicle left the gas station?
Yes.
No, Officer Vanderwerf said that he saw him pump the gas and get in the car in the driver's seat.
Yes, I don't dispute that, but at some point, they didn't immediately try to pull the vehicle over, I don't believe.
Oh, so are you suggesting that there was some time where it might have pulled over and the driver could have changed, what you're suggesting?
Yes, that is certainly possible, and I think the witnesses were consistent.
Possible.
There was a passage of time, and we don't know what happened with that vehicle during that passage of time, whether there was some type of switch where people were getting in or out of the vehicle, we don't know. And my point in bringing that to the court's attention is there was no testimony that anyone could identify the driver as it was attempting to be pulled over. Yes, they said that they saw Mr. Green in the driver's side earlier, but again, there's some passage of time between that and when the vehicle was attempting to be pulled over. So that is a strong part of my argument on that. Certainly the vehicle itself does not come back to Mr. Green in any way. That was a consistent part of the testimony.
I'm sorry, I didn't hear what you said.
I said that was a consistent part of the testimony.
I didn't
is that
I heard
the
that part. It was what you said.
ownership of the
Oh,
vehicle
ownership.
was not traced to Mr. Green in any way. As it relates to the controlled substance count, again, the consistency among the testimony is that it appears they were focused on one of the other occupants in the vehicle, Mr. Idris Woods, who they are familiar with, who does have a history, it sounds like, of drugs or drug trafficking and firearms. There was no such testimony similar to that for Mr. Green. And there was no witness testimony that there were any narcotics or controlled substance found on Mr. Green's person. No one saw him discard any controlled substances. There were no admissions made by Mr. Green that he acknowledged any ownership or knowledge of any controlled substances that may have been found on scene. So those are my arguments as it relates to those counts that I would ask the people to deny the people's motion for bind over. And I fully acknowledge, I think it relates to the resisting and obstructing charge. I think that is certainly the strongest charge among the three that the people have, but nonetheless, I am going to be voting that as well. Thank you.
As far as the argument, as far as identification for the criminal lead charge, it seems as though there is a concession that we have evidence that he was driving the car at the time they left the station. And so we have that. And then Officer Vanderwerf was initially surveilling the car when it left, radioed out a description. And then, of course, Trooper Morgan then found the vehicle that was described. Of course, it is possible that for some reason they decided to pull over and then swap out drivers. But I don't think that that is such a probable scenario that it would warrant not finding this over.
Why is that? Why not?
Well, I would submit that it's a probable cause basis, and it is just not. People don't usually say, you know what we're gonna do, we're gonna pull over and we're gonna do a little shuffling around. Now someone else can. It's not usually
Or
pull out.
they could, if they think the police are onto them.
It's certainly
That's
possible, but
completely reasonable. If we see the police trying to get us, and I think I might have a warrant or something, then we can. Probably be best for you to be quiet right now. You probably, you could switch, that's reasonable, it's probable. What we're trying to figure out is there more than mere suspicion that he was actually the driver, and that he maintained being the driver at the time that the vehicle was attempting to be pulled over. That's the concern.
okay, understood. I think that what I would say, he was of course found later, in the vicinity of the vehicle. And it doesn't, I don't see the logic in saying, okay, I have a warrant. I'm still going to be in the vehicle that's being followed by the police, but someone else will drive.
In the vicinity of the vehicle, but the vehicle was found at a location that they already connected to this Idris Woods person. And this vehicle is not the defendant's vehicle.
Yes, this, we know that he got to that location.
We know that
So-
who got to that location?
The defendant got to that location.
So did Idris
So-
Woods, allegedly.
Yes, I think that the reasonable inference is that two of them went there together in the vehicle.
Yeah,
that
but how come this
yeah.
can't be Idris Woods drugs?
Why can't it be a
Yeah,
Wood drugs?
yeah.
Well, because I think there's probable cause to believe that the drugs belong to this defendant. based on
Because
the-
he was driving?
No. I believe there is probable cause to believe that they belonged to the defendant because they were found within arm's reach of the defendant in a yard. It appeared as though he was, I guess, it was found within arm's reach of him in a yard where there were no other non-police people present. And there was a struggle with police where one can reasonably infer that it could have fallen off of like out of a pocket or something. So I do believe there's probable cause to believe that, you know, there's no evidence that this English person was in the backyard. It doesn't sound as though they were successful in finding him at that point in time. So, you know, it's certainly possible that maybe he just got out of the car and took off running and tossed it into that backyard, and then they just happened to arrest him right next to it was tossed. That's, you know, I'll concede that Mr. Austin is going to have some arguments he can make to the jury.
Yeah,
I
I think we
don't
all
envy
agree
the
this is probably
person-
not the strongest case.
I don't envy the circuit court attorney who
Agreed.
gets this dropped on.
I don't-
But
I
I
don't
think that
think-
we're at a bind over.
I agree. I don't believe, I think everyone realizes it's not the strongest case, but is there more than mere suspicion, which is the burden that the prosecution has to establish at this time? So this is a preliminary examination, this is not trial. You don't have to prove each element beyond a reasonable doubt. Just gotta give me some credible evidence or testimony to show me more than mere suspicion that you, engage in the act and count to a police officer assaulting or assisting obstructing. I believe based on the testimony that that's been clear. That's not a question. It's the strongest, I think. Now we have the fleeing and eluding. The fleeing and eluding is where it gets a little murky for us. We have testimony where you were allegedly seen pumping gas with this distinctive jacket on at a gas station at or near, I think it was on Cedar Street in Lansing, Ingham County. And that you were also seen by Officer Vanderwerf then driving off in that vehicle. It's undisputed, I think, by all the testimony. There was a passage of some time. And so if there's a question now is whether or not whether the vehicle was prompted to pull over, whether or not this defendant that was identified in the court was the same person at that time driving, because they could not identify or see at that time who was driving. Possible that he was, possible that he was not. I think it's more possible that he was because he was last seen driving the vehicle. So I think there's more than mere suspicion that he was the one driving the vehicle at the time that they later made contact and tried to initiate a traffic stop, and that there was a failure to pull over and stop the vehicle. So I find that there's sufficient probable cause as to the fleeing and eluding, and that will be bound over as well. The people have already made a motion to dismiss count 1 or adding a count 4. Possession of cocaine. And again, the same question. It's possible that these baggies or Ziploc bags of narcotics could have belonged to someone else. It's also highly possible, I think, that it could have belonged originally or in the ownership of Mr. Woods. And that's only because this is the officers later find this defendant at the address that they knew was already associated with Mr. Woods. However, what makes it more likely possible that it was the possession or the narcotics of this defendant is that the location it was located when they found him after the struggle, during the struggle. They didn't find Mr. Woods there. And so is there more than mere suspicion that based off where these narcotics were found and the location of this defendant when they were found, that they belong to this defendant? Yes, there's more than mere suspicion as to that. Still not the strongest, but enough to get the case over to circuit court. So the counts as amended will be bound over to the circuit court for further prosecution. The bind over date is going to be the 22nd of July. Your attorney will be made aware of your next court date and the date that you need to appear in circuit court, okay? And he is going to be serving time in Department of Corrections, so we don't need to address bond at this time. Any additional matters for the record?
Only the people will be requesting a transcript.
I have nothing additional at this time. I'll back up Mr. Green, Your Honor. Thank you.
You're all set. Great to get some air.
Brewer, I think his intention is to contact
Yeah.
our office and
Yeah.
reapply.
Okay. On the record in the matter of the state of Michigan versus Aaron Brewer, 25-00532, appearance, please.
Ross Marshman on behalf of the people.
Mr. Brewer, you can come forward. State your name, please. Okay, this matter was scheduled for an exam today. You are seeing the building. You do not have an attorney at this time. Okay, Mr. Austin, you were making a statement on his behalf. What were you saying to the court?
Yes, Your Honor, he had applied to our office. He was denied as not being economically eligible. Talking with Mr. Brewer, it sounds like it's his intention to contact our office and either go through the denial process or reapply. It sounds like he may have had some changes in his financial circumstances, so I did provide him with the necessary contact information for our office to do that.
Thank you. Okay, so I will find good cause based on that to reset your matter. You did have the right to have an examination within 21 days, but because you need to appeal to try to see if you can get public defender, I'll find good cause so this can be reset, okay? You're gonna get your new PCC and preliminary examination.
PCC, July 23rd at 9:30. And exam August 7th at 8:30.
Okay. We'll get you the numbers to appear for those dates. Do you have any questions at this time? Okay. Any additional matters for the record today?
Nothing for the people. Thank you.
Thank you. We're gonna get you a nollie for Williams. When you go down, it gives you see if you can do an intake with Mr. Henson for us. He wanted to.
Yes, I can do that.
Thank you. Okay. That was your Nicole Debatistas here. Is that a waiver?
Wait,
Oh, okay. State of Michigan versus Nicole Debatista, 26-01320. Appearance, please.
Ross Marshman for the people.
Jacob Riley on behalf of Ms. Eastern, who is present. As stated.
Ms. Debatista was supposed to happen in ceremony today. There's going to be a waiver. Is that for a global resolution?
Yes, Your Honor, it's my understanding that the agreement has been reached, where this case will ultimately be dismissed following sentence on a different case that's already in the circuit.
What's going on?
Friday at 54A.
In the top. Okay. And so, Ms. Devertisa, that's how you want to proceed, correct?
Correct,
You
Your Honor.
understand you have the right to have a preliminary examination on this file.
Yes, Your Honor.
You have the right to require the prosecutor establish sufficient probable cause that felony was committed and sufficient probable cause to charge you as the person who committed the felony, correct?
Correct, Your Honor.
You wish to unconditionally waive your examination?
Yes, Your Honor.
Okay, no one's threatening you to do that, right?
Correct, Your Honor.
Waiver to refusal involuntarily made, your bind over date is July 22nd. That's the date the circuit court's gonna receive this file, not a court date for you, okay?
Thank you, Your Honor.
Your next court date will be a pre-trial, your attorney will be made aware of that. Do you have any questions today, ma'am?
No, Your Honor.
Any additional matters for the record?
No.
Nothing on behalf of the people. No, Your Honor.
Bond will continue, you're all set.
Okay, thank you.
I don't think so. Have you seen your attorney? Sir?
We,
Yeah.
my attorney, he gave me a date of like the 22nd.
I'm sorry?
My phone died, but he gave me a date of the
For what? A date for what?
22nd. But I was told twice that I had a court date today at
You
9:30.
do have a court date today. We're trying to figure out where your attorney is.
I don't know.
Didn't he do this last time?
He came late.
I can't wait last time. But I ended up coming and then, you know, he was able to see me a little bit later.
And you said your phone is dead?
My phone died, yes, ma'am.
Yeah, your attorney's supposed to be here.
So yeah, because I had a couple different court dates for like one was for the city of Lansing. I wasn't sure if it was that one because the last date that he gave me was the 22nd. That's what he had texted.
Hi, good morning.
Is this Attorney Levine?
This is he. Yeah.
This is Judge Simmons. How are you?
Good morning. I'm doing well. How are you actually? Very good. How are you?
Well, I'm okay, other than it's 90 degrees in my courtroom. Your client has been here since about 9 o'clock because there was 8:30, because you were supposed to be here for his preliminary examination and we don't see you.
Yeah, I'm on here. I'm on, unless there was a miscommunication on my part. And I own that. I checked my calendar twice today. We're talking about Mr. Pettis, correct, Your Honor?
Correct.
Yeah, that's on me. I have no idea the reason that it's not reflecting up on my calendar. But yeah, I'll tell you what, I'll make this happen.
No, I was going to be requesting an adjournment.
Okay, no, we're gonna go ahead and reset it. It's too hot in here anyways. I can't.
Okay.
Feels good on here.
That's on
You
me.
feel
I'm
good?
sorry.
You got the fan right in your direction too. But I'm wearing a wool jacket.
Yeah, I know.
No, Your Honor, seriously, I'm sorry. Yeah.
Your apology has to be to your client, not to me. Okay.
I appreciate you, Your Honor. Seriously, I'm sorry that this is even, I'll take care. Can anybody else hear me right now or no?
You're on speaker for sure, because the prosecutor had to hear this conversation.
Yeah, I'm here.
Okay, all right, but yeah, I'll just keep it, okay, all right, okay, no, thank you. I
Okay, let me
appreciate
get you a
and I'll
new
make sure-
date right now.
Yep, absolutely, please, thank you, Your Honor.
August 7th at 9:30.
August 7th at 9:30.
Absolutely, and I'll make sure that works. August 7th at 9:30, I will be there. And again, my apologies for that to you and everybody there, honestly.
Thank you. We'll get you a notice, Mr. Perez.
Thank you. Your Honor.
Thank you. Bye.
Thank you.
And then, okay, we did that. This is, are we running Lindsay? It's gonna be a waiver. Okay. And then we're running, how many witnesses are on Buck?
1 to 3, depending on how the testimony comes in.
Well, give us 5 minutes. We're on the record in the matter of the state of Michigan versus Leslie Glenn Buck, 26-01559. Appearance, please.
Ross Marshmead on behalf of the people.
Thank you, Your Honor, and good afternoon. Jared Austin, appearing on behalf of Mr. Buck. He is present with me at council table.
Today was the date that was scheduled for Mr. Buck's examination. Are you ready to proceed?
Yes, Your Honor.
You are as well.
Need preliminary matters.
Nothing on behalf of the people.
Mr. Your Honor, it sounds like there may be multiple witnesses, so if that is the case, I would ask for an order of superscription.
Superstition, ready? You can call your witnesses.
The people will first call Alina Mata. Stand right here, currently face the judge, and after she swears you in, you'll have a seat.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Yes. You can have a seat. So there's a microphone that's in front of you. The purpose of that microphone is so that everything that's stated in court could be recorded, but the microphone will not amplify your voice for us to hear you, okay? It's really warm in here, so we do have multiple fans going, and it's drowning out some sound. So I'm going to ask you to speak louder than your normal inside voice, okay?
Okay.
Okay. If there's an objection from any of the parties, you will stop speaking. I would need to make a ruling on that objection, and then I will tell you if you're allowed to give us that answer or not. All of your answers must be verbal, no heads, nods, head shakes, mhm, uh-huhs. If you forget to answer yes or no questions with yes or no, we'll just ask you if it's a yes or no, okay?
Okay.
State your first and last name and spell it.
Alina Mata, first name Alina, last name Mata.
Okay, Alina, I'll start with some background questions. First off, do you know someone named Leslie Buck?
Yes,
How do you know Leslie Buck?
he's my child's father, and I had a previous relationship with him.
When you say previous relationship, are you referring to a romantic relationship?
Yes,
And how long did the two of you have a romantic relationship?
probably 5 years.
And you two just have the one child together?
Yes, sir.
Have you ever lived together? Now, do you know someone named Alicia?
Yes, sir.
How do you know Alicia?
That's my sister.
And do you know someone named Doyen Frazier?
Yes, sir.
How do you know Doyen Frazier?
I would say I had a romantic relationship with him.
You had a romantic relationship with Doyen?
Yeah.
Was that after the conclusion of your relationship with Mr. Buck?
No, it was during.
Okay. Now, Leslie Buck, do you see him in the courtroom right now?
Yes.
Could you please tell me where he's sitting and describe his clothing?
He's sitting to the left of me, and he's wearing navy blue clothes.
Your Honor, could the record reflect the witnesses identify the defendant?
No objection.
Identification is noted.
Now, the address 714 Clark Street, does it have any significance to you?
Yeah, that's my home and my mother's home.
You said it's what?
That's my home and that's my mother's home.
Okay.
Thank you. And were you at that 714 Clark Street, is it in the city of Lansing?
Yes.
Is it in Hingham County?
Yeah.
And were you there on June 4th, 2026?
Yeah.
Now, we're going to talk a little bit about June 4th, 2026, okay? At that time, was Mr. Buck living in that home with you?
No.
And Did you come to have a phone call with Mr. Buck that day?
I had called him a few times and then he did not answer, so there was no over the phone talking, but I did reach out and make a phone call to him.
Now we're going to talk about sort of, I guess it's more late night of June 3rd and early morning of June 4th. Who were you in this house with?
I was in the house with my mother and my nephew, which is my son, and my daughter, and Dwayne Grace.
Okay. So you were there with Alicia, Doyen.
Alicia was not there.
Alicia was not. So you were there with Alicia's child?
Yes.
Alicia-
He was right there
Okay.
as well.
You're there with Alicia's child, Doyen, and your mom.
And my daughter.
And your daughter. Okay, thank you. And let's talk a little bit about this this location. I already said house. Is it like a single family house? Or is it, just describe the structure?
It's just a home, like a regular couple bedroom home.
Okay, so it's a house with like a yard, a couple bedrooms. Is it 1 floor, 2 floors?
It's a floor of a basement and an attic.
Okay, so you have a basement, you have a main floor, and then you have an attic above it.
Yeah,
And do you have a bedroom on the first floor?
my bedroom, I would say, it's not like, it was an add-on to the house. So it's it's considered main floor because it has a door to the outside too.
Okay, so there is a door to the outside on your bedroom.
Yeah.
And did there come a time early on June 4th when Mr. Buck entered through that door?
Yes, he did.
And did you invite him over, or did he just let himself in?
I would say he just walked in, but I would also say as well that he always comes over. He always just walked in. He never technically needed permission. I would sneak in a sense,
Okay.
through my door. And so, because he would come to see his daughter or come stay with him. So I wouldn't consider him for rape.
Okay, so initially he entered in, and while you hadn't explicitly invited him, he just sort of had the freedom to come and go.
Yeah.
And where was Dwayne at the time that Mr. Buck came in?
He was in the bedroom. In my bedroom.
I can't hear.
He was in my bedroom with me.
Oh,
And then how did Leslie Buck respond to Dwayne being in the bedroom?
He was agitated because we were in a relationship and I was infidelity, if you want to call it that, to me. Yeah.
Did there come a time when there was some sort of a physical confrontation between Leslie and Dwayne?
Yes, Leslie Buck and Dwayne Price, they did fight in the home.
They got into a fight in the home?
Yeah.
And did there come a time when Leslie Buck became, I guess, angry with you?
Angry, yeah.
Did he yell at you or anything like that?
I wouldn't even say yell. We just kind of had an argument
Okay.
within the time frame because it all happened quick. It happened, all everything happened within 5 minutes.
Now, did you have a conversation with a police officer named Craig Fleeser?
If that's his name.
And do you recall if you told Craig Fleeser that Mr. Buck was yelling at you?
I could have, but
Now, during this initial time when he was in your house, did Mr. Buck ever strike you?
I mean, I was trying to break up the fight.
So my question was, did he strike you?
Yes.
Can you tell me about how he struck you?
It was just a one-time open hand hit.
And where in your body did he hit?
It was like sort of.
So he struck you on your face.
Yeah.
And I guess, sort of how close were you to him at the time he struck you on the face?
Arms, legs, and the hip.
Okay. And where was Doyen at the time he slapped you?
The line he at that point was outside.
Okay, so Doyen was no longer in the immediate vicinity of these two at the time he struck you.
Wait, she said Joanne was no longer in the immediate.
In the immediate vicinity.
When, at the time when she was struck.
Yes. Just a background question. Do you know someone named Alyssa Mata? Okay. So if the police report were to refer to someone named Alyssa, that was likely a typo. Is that
Yeah, that was
fair to say? Okay. But you have a sister named Alicia.
Correct.
And did you happen to see any sort of confrontation between Alicia and Leslie? Okay. Do you recall telling the police that you saw Alicia yelling at us?
Yeah.
Okay. Now, did there come a time when Leslie Buck left the house?
Yeah.
And did he leave through that door in your bedroom?
Yeah.
And at this point in time, did you close the door?
When he left.
Yes.
Yeah.
Did you lock the door?
Yeah.
Okay. Now, at some point in time, now after you locked the door, did Leslie Buck leave?
Yeah.
Did he attempt to return to the house?
When he left, he went.
Okay. Did he ever do anything to the door to regain entry into the house? Ms. Mata, you're under oath, and if you attempt to protect him, you're jeopardizing yourself. Do you understand that?
Correct.
Now, did he attempt to re-enter the house?
Yeah, he did.
Okay, what did he do to re-enter the house?
The door handle went out there, locked it, because I was still holding on to the door to lock it. And he kind of basically pushed it open.
Push it open. Did you ever hear any sort of banging on the door?
No, because when he came back to the door and I was in the middle of locking it, he had said open the door. And I was trying to open the door. And then-
So you were trying to open the door. Did he cause any damage?
I would say within pushing down.
Showing defense table equals pros exhibit 1. Running man, question witness. Approaching with exhibit 1. Do you recognize exhibit 1?
Sure.
And is this your door?
Yes.
And down here, is that damage to the door?
Yeah.
Okay, and is that the damage that you caused to your door?
Yeah.
And does that fairly accurately depict the damage done to the door?
Yeah.
Okay, Your Honor, at this time, the people move to admit pros exhibit 1.
Without objection.
I'll just show it to the court instead of going through the screen share. Now, just to clarify, your testimony today is that he caused that damage by pushing the door open while you were trying to open. Is it true, ma'am, that you told the police that is from him striking the door?
Striking as a fight. Forcefully opening.
So he was attempting to forcefully open the door while you were opening it for him. That's your testimony today?
Yes.
Okay. Now, you indicated he's the father of your children, right?
Correct.
And fair to say that you want him to be able to have access to your children, be a parent to your children?
That would be the goal.
Okay, and if he were to go to prison, it would be difficult for him to be a parent to your children. Is that fair to say?
Absolutely.
Okay. And at the time you spoke to the police, did you speak to the police immediately after all this happened?
They came about 10 minutes.
10 minutes. And during those 10 minutes, did you have time to sit and think about the consequences of him possibly going to prison?
I
And
didn't
since
have to
then,
think about it.
okay, since then, have you had the time to sit and think about the fact that him going to prison means you wouldn't be with your children?
Correct.
Okay. And is it possible that those thoughts are affecting your testimony today? Oh, just give me 1 second, I'm trying to get some. Now, what, if anything, did he do upon re-entry into your house?
There's what I had said when I said that we have argued and he hit me.
Okay, so when he hit you, that was after he did the damage to the door?
Yeah.
Okay. So just make sure we have the timeline clear. At some point he left, and then you closed the door, and then he forced his way back in, and that's when he hit you?
Yeah.
This is so unclear, because previously I thought you said, man, that you were trying to break up the fight.
Yeah, I was trying to break up the fight, but
That's not when he hit you?
no.
Okay.
I have no further questions.
Cross-examination.
So, day that is the subject of this hearing, June 4th, 2026, what was the status of your relationship with Mr. Buck at that time?
We were intimate together.
Were you said you were intimate together?
Yeah, we were still in a,
You were still in a relationship?
yeah,
But you were still a couple?
yeah.
Okay. And what was your relationship on that date with Mr. Frazier?
Sexual relationship, nothing more,
Nothing, what was the last part?
nothing more, nothing less.
Okay. And is that something that you had informed Mr. Buck of, that you were having that type of relationship at that time with Mr. Frazier?
No.
And the home that we're talking about here, who owns that home?
My mother,
Okay. But you live there?
yeah,
Okay. You live there full time?
yeah,
Okay. And so Alicia is your sister?
correct,
She lived there at home,
yeah,
but your testimony, she was not present for this?
she was not inside the house, no.
Was she on the premises at all?
When I eventually went outside, she was outside on the premises, but before that, I had not seen her prior, so when I went outside.
So she was, what, outside on the yard or where at?
When I seen her, she was outside on the yard.
And what point in the sequence of events did you see this?
That's the first,
Yes.
when, after everything had cooled off and I had went outside,
So after everything had died down, essentially?
yeah,
Okay. And is it Alicia's child was in the house at the time?
correct,
How old is her child?
17
Is that a son or a daughter?
son,
Where was he at when all of this was occurring, if you know?
in his bedroom attic.
Did he ever come out from his bedroom in the attic during any of this?
No,
Now, testimony is that Mr. Buck came over, is this nighttime we're talking about, or what time are we talking about?
nighttime, early morning,
Are we talking after midnight or before midnight?
yeah, pretty much.
And you essentially said Mr. Buck came through the door as he always did?
Yeah,
Okay. And you said he never needed permission to do that. And so that was routine for him.
yeah,
And you're not saying when he came over that early morning hours, like he had done many times before, that that was done against your will or without your permission?
no, he did it frequently.
And upon him entering the home, you did not tell him to leave or get out of here or anything like that?
No, but I told him when he did enter. And I knew he was gonna be mad about what he seeing the wine. I said, you don't do this. Yeah,
But you didn't say, hey, I don't want you in the house, get out of here. You're not welcome here. Nothing of that sort. Did you?
not to my knowledge. No.
Okay. That's something you likely would have remember if you would have said something like that. Is that correct?
I would believe so.
And that's because he had your permission to be there at that time. Is that right?
I would say like yes and no. Like I said, it was a frequent thing for him to do.
Wasn't anything out of the ordinary.
No,
Okay. He didn't come over in a way that he hadn't done many times before.
yeah,
He didn't pry open a locked door or barge through the door when he first come over there, did he?
no. It was my last season.
So he was unaware of the type of relationship you were having with Mr. Prince.
Yeah,
And is it safe to say during all of this encounter, you were rather upset yourself,
yes, I was.
emotional?
Yeah, I would say.
And you've been consuming any alcohol at all that night?
I like a shot earlier, but nothing to be drunk or, and that was way earlier in the night. So at the time I was sober.
And when you say a shot, you mean that in the literal sense, just one shot, or do you mean that more in a colloquial sense that it could have been multiple?
Like literally the shots that you buy at the store.
Right. And that was a shot of what?
Jose Cuervo Silver.
What, I'm sorry?
Jose Cuervo Silver.
And were you taking any type of pain or psychotropic medications that night?
No.
And I want to go over the part of your testimony again where you said there was a point where Mr. Buck struck you. Okay?
Okay.
Is it true in your initial testimony here today, you said that had occurred around the time that you were trying to break up whatever was going on between him and Mr. Frazier?
I dang near shouldn't even said that. I did try to break up the fight, but that's not what I did. No.
But that was not my question. That is what you said though earlier in your testimony, was it not?
No, that's not what I was insinuating.
So you did not testify here just moments
No,
ago.
I
that
said
when-
that.
Well, let
Yeah.
me finish my question.
Sorry.
So are you saying that just a few moments ago, you did not testify that Mr. Buck, when he struck you, it was around the time that you were trying to break up what was ever going on between him and Mr. Frazier? Did you not testify to that?
No, because the exact words did not come out of my mouth. I did not say exactly that is instruction.
You were talking earlier in your testimony about you and your attempts to break up what was ever going on between Mr. Buck and Mr. Frazier. Is that true?
Yes.
And then shortly after that part of your testimony, you said that Mr. Buck struck you. Is that correct?
Yes.
And you did not say in response to that questioning that that was after this, the second time Mr. Buck came in with the door. Is that true?
Could you go on?
Yes.
Please, sir.
You did not state at that time that Mr. Buck struck you the second time he came back after the door incident.
Correct.
Your testimony, there was no confrontation at all between Mr. Buck and your sister. Is that correct?
Correct. To my knowledge, and I wouldn't.
You certainly did not witness such a confrontation if there was one. Is that correct?
No, yeah, no, I did not.
Did you contact law enforcement then?
No.
You've still been upset and under whatever emotional state that you were in when you did speak to law enforcement. That-
Yeah.
Thank you. Tell the question back.
Now, you testified that Alicia is your sister, right?
Yeah.
And was Alicia there at all that night?
And the
Was
Did
she
you
present
mean
when you were
within-
speaking to police? Was Alicia present?
yes, at that point. She was.
Well, what do you mean at that point? When did Alicia get there?
I'm not sure. I was inside the house. Like I said, at that point, I had heard her outside, but I'd never seen her until I went outside myself after everything.
The prosecutor previously asked you who was at the home, And you didn't, you said she was not there. So she came after or during this incident, is what you're suggesting?
Yes,
Okay.
I had not seen her previous prior.
Do obviously the police there, do you know who contacted the police?
Yeah.
Who contacted the police?
Alyssa.
I don't have a question.
I just have a follow-up. Because I'm just still not understanding the sequence of the previous statement on direct, or I should say the relevance of why she said it. So, Ms. Mata, when you were originally asked by Mr. Marchmina, as you were narrating what took place when the defendant allegedly first entered your bedroom or your home, you stated that he and Mr. Frazier fought, and then Mr. Marchmina asked you, did something happen between you and the defendant where he put his hands on you, and your response was, well, I was trying to break up the fight. Why did you say that?
Honestly, because I was gonna lie and say that, but I'm not gonna lie. And that's not gonna happen.
Thank you for clarifying. Any further questions?
No.
Just one moment. if I may, briefly, if I may. Due to your last comment was saying you were something to the effect of you were going to lie, but now you're not going to. Did I hear that correctly?
Correct.
So are you saying that there was at least one part of your testimony that has been incorrect today?
I would say yes and no, because when, and like you stated, when they asked, or whoever asked if I got struck, I said, well, I was trying to break up the fight. But that's not, I did not state in full sentence and say that's when I was struck. But yes, I would say yes. Okay, part of my testimony was not correct today, which would be that part.
And what other parts of your testimony, if any, have not been correct today?
Just that part.
So just that part was incorrect when it seemed to be implying that when you were struck, it was during the altercation between Mr. Buck and Mr. Frazier.
Yeah.
But your testimony is that part was untruthful, but the rest of your testimony is truthful.
Yes.
Thank you.
And that's why I only said it one time.
Thank you. There's no question posed to you. Thank you.
Can you read it?
I know you're right.
Thank you, Ms. Marley. You may be excused. There is a sequestration order, so that means you're not allowed to discuss your testimony with any other witness, okay?
Oh, okay.
Okay.
Other people will call Alicia Meyer. All right, walk right up here and then turn to face the judge, and then after she swears you in, you'll sit in that chair.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. You can have a seat. There's a microphone that's in front of you, and that microphone is not going to make your voice louder in the courtroom. It's only so that the system can pick up everything that's stated. So I need you to make sure your responses are loud and clear. And then we have a lot of fans in here because it's so warm. So you may need to speak louder than your normal speaking voice, okay? Yeah. All of your answers must be verbal. That includes yes or no answers. So no mhm, ahas, or head nods, head shakes. Otherwise, we'll ask you if it's a yes or no. If either of these attorneys yell objection, you just stop speaking. I am going to make a ruling on that objection and then tell you if you're allowed to answer their question. Okay? State your first and last name and spell it.
First name is Alicia, Alisha, last name is Mata Gibson, MATA-GIBSON.
You can proceed.
Okay. Lisha, just some background. You know someone named Leslie Buck?
Yes,
Yeah, and how do you know Leslie Buck?
he is the father of my niece, which is my sister's daughter.
Now, do you know someone, speaking of your sister, do you know someone named Alina Mata?
Yes, I do.
And is that her twin sister?
Yes.
And is that the sister who is the mother of Leslie Buck's child?
Yes.
Yeah, and do you see Leslie Buck in the courtroom right now?
I do.
Could you please tell me where he's sitting and describe his clothing?
He's in to my left in a blue suit.
Your Honor, could the record reflect the witness have identified the defendant?
The objection.
Without objection.
It's noted.
Now, 714 Clark Street, does that address have any significance to you?
Yes,
What is the significance of that address?
I currently live there.
And who do you live there with?
I live there with my mother, my sister, my niece, and my son.
And which sister is it you live with?
Other than mine.
And we're going to talk about the early morning hours of June 4th, 2026, okay? Did there come a time when you called 911 on that day?
I did.
Okay. And was that 911 call in connection with interactions that your sister had with Leslie Buck?
Yes.
And if you were to hear your voice in this 911 call, would you recognize it?
Yes.
All right, I'm showing defense stable of people's proposed exhibit 2. Your Honor, may I approach the witness?
Okay.
All right, just play it kind of quietly and then I'll pause it and ask some follow-up. Did you recognize the voice on that call?
Yes.
And was that your voice?
Correct. Yes.
And at the time you placed that call, was the situation kind of ongoing?
May I elaborate? Yes.
Yes, it was kind of ongoing.
Yes.
Okay. And were you, how would you describe your emotional state when you placed this phone call?
Worried, concerned.
You were worried and you were concerned.
Right.
And did you describe things that were happening on that 911 call?
Yes.
Okay. And the things you were describing, were those things the source of your worry and concern?
Yes.
Okay. Right, it's time that people move to admit exhibit 2.
You said exhibit 2, correct?
Yes.
Any objection?
No objection.
Admitted.
Your Honor, if I may, I can give you easiest if I just bring my laptop up and play it for you.
That's fine.
People will now publish exhibit 2 to the court.
911, what's the location of your emergency car here right now?
Are you able to hear it?
See, very close.
Yeah, I'll bring it up here.
Right now. What's the address that you're at? Right now, that's what the car now. Now, please, now. Now, 714 Clark Street. Yes. Okay, what's your name? Yeah, I need someone right now in my house. Okay, what's going on? Where's the car Get the fuck out. 911, 911, 911. You're on the phone with 911. Now, he's already has fucking minors, all that. I don't give a fuck. Who was over there? Weirdo? You weirdo? Well, you stop here. Fuck out of here. 1040 Clark Street. I will get his license plate number 2. License plate number. Okay, what's going on there? He's being at 8712. GPS 8712. Okay, why are you giving me a license plate? No. You must be trying to get my sister. Let's go. Okay, what's going on there? Why are you giving me his license plate? Hello, can you hear me? Yes. You understand? You just left my house to get on my sister. Oh wait, who is he? You understand? He's being my sister's ass. Okay, does she need the medic? What does right now? Does she need the medic? I'm just telling you that you just said I gave you a license plate number. I wrote it down. I put it in the call. I'm so sorry. I'm really not trying to fucking. He just fucking literally, you know, my sister and okay. What's your name? I'm Alyssa. Listen, I can get help out, but you need to use your words to answer my question. Your job though. Okay, what kind of car was he driving? I just gave you his license plate number. I know that. What color was the car? I'm sorry? What color was the car? Black. The color is black. Okay. What direction did he go? He went down, like, towards Brandor area. I don't know what direction it is. I'm so sorry, but he went that way. That's okay. Looks like he went east. Did he go down Saginaw there? Who's driving? Sorry. Are you fucking stupid? I'm so sorry, bro. Like, you know what? You know what? My fucking sister can learn right now. Fuck it. When I'm going dumbass bitch. You're a dumbass bitch. Why the fuck would you do it? Why the fuck would you do that? Why the fuck would you do that? Why the fuck would you do it? Alyssa. Are you dumb? 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 Alyssa. What actually your face? What? My baby in my fucking hand. I don't care. What? You're entertaining all these niggas. That just we're right to come here and whatever the fuck you did. Give him a fucking thing. I'm trying to find him. No. Why would you do that? Hello. That nigga is got a fire in her hands. What's wrong with you? Are you serious? Did you ever do this? She's over here doing everything. You're got no name. Stop. Hello, Alyssa. Doctor, was that this? No, because now, I'm hurt. You're a dumbass. You're a dumbass. Alyssa. What are you doing? Alyssa. Hello. Where's the light? I don't know. Hello. Somebody, and knowing that you are crazy, bro. Don't be funky. Actually, 911 should never been on. I thought you were very good. Stop. Alyssa, can you hear me? You know what? How is Buster blaming your fault? That doesn't matter. She brought him over. She brought him to come here. She's on the phone. The only reason she's here is because the lion's here. How does she know that? Hello. Hello. It doesn't matter, man. Honestly, my sister is an idiot. Bye-bye. Okay, I have help coming out. They're gonna come and check on you guys, okay? No, actually, don't actually didn't say anybody out. My sister's dumbass. Don't even worry about it. Because of what was said and heard on the call, they will come out and check your guys. Oh, they're fine. Let them come out because I'm like, go ahead, because my sister can explain the whole situation. When you can talk to officers, tell them what you talked to, okay? Yep, my sister explained the whole situation. Somebody I didn't say, Alina, shut the fuck up talking to me. Shut the fuck up talking to me. Because Boomer would never ever pop up for no fucking reason because you're a dumbass. I just wrong. Yeah, I was frank. You were my problem. We're sure to get that. Mom, please don't stop. Don't talk to me. We're not bullshit. Are you drinking and driving? Stop talking to me. I'm stupid now. You know what, Lena? You know what, Lena? You know what? You know what? Learn this fucking lesson. I would never have your back in my fucking life. How like that? Ever. This, what? The only reason this motherfucker pulled up is you are a fucking messy ass bitch. How? You're messy. It's literally very innocent. You're messy, bro. You're a messy ass bitch. You're
All right. Going back to the beginning of that call, you described someone beating your sister's ass. Who was the person you were referring to? And you gave out a license plate number. What was the reason you were giving a license plate number?
I was using a license plate number to confirm that that was the vehicle that was occupied and whom belonged to the defendant.
And then it belonged to Mr. Buck? Okay. Now, did you see the defendant beating his sister's ass?
No, I did not.
I'm sorry? I couldn't hear the answer.
Oh, no, I did not.
Oh.
Okay, how did you know that he was beating his sister's ass?
So I may I explain the situation at hand?
My question is how you knew he was beating his sister's ass. So why?
Because I heard a scream after I heard a loud, what seemed to be nothing like a gunshot or anything, or something like as something hitting something, and my sister screamed.
Okay. So where were you when you heard something hitting something?
I was inside my vehicle.
Okay, so had you just like pulled up to the house?
Yes, I had been there. I was just inside my vehicle, my vehicle is close to the entranceway in which my sister resides.
Okay, so there is there a door that leads into where your sister stays? Yes. And your car was near that entrance?
Yes. And
there was a time when you heard some noises?
Yes.
And could you describe the noises that you heard?
Again, I heard a loud noise, as in bang, like something hitting something. And then once that happened, a loud scream that came from that direction of where my sister's room is, which again,
and did you recognize the voice that was creating the scream?
Yes, yes.
So whose voice was it you were screaming?
My sister.
And then did you at this point approach the entrance or anything like that?
I approached the entrance, but at that moment felt that it was better for me to call 911 to de-escalate the situation because I did not want to get involved.
Now, did there come a time when you had any knowledge to damage having been done before?
Not at the time.
Okay. Did you eventually talk to the police?
I did.
Did you tell the police about the door being kicked in?
I can't necessarily recall if that's the description I gave. I after the loud noise that I had heard prior to the screaming, I thought that was the situation.
Okay, so you can't remember what you told the police. Is that in regards to the door, you're saying you can't remember what you told the police?
No.
If you were to watch a little piece of your statement to the police, that would refresh your memory. I'm showing the defense table. Police body camera video. Your Honor, may I approach the witness?
What am I? Just say. Wait, the back. That he busted through.
If you were to read the transcript from what you said, could that refresh your memory?
Oh, all right, sorry.
Did that refresh your memory?
Yes.
Um, what knowledge did you have regarding any entry?
The only knowledge that, again, as stated, that is the sound of somebody keeping in the door. I did not physically see that. And then allow scream proceeding after.
So you heard a sound that was consistent in your mind with someone kicking the door. Correct. And then it was after that sound that you heard the scream. Correct. And you indicated previously that the scream was your sister's voice. Okay. Why were you calling your sister a dumbass on the 911 call?
Because I unfortunately I had other previous.
You know what, we can actually move that. Take us in stuff that we don't need to get into.
I think I
We can just move past that. Give me 1 second. Now, when the police arrived, did you have any expectations regarding whether your sister would be forthcoming?
Object, this is going to object to relevance.
Going to pertain to the sister's spectral.
Your question was whether or not she knew if the sister was gonna be
If she
forthcoming.
expected that the sister would be forthcoming.
Not only is it, I'm not sure if it's relevant, it's also causes for her to speculate.
Well, I can try to lay some more foundation.
Okay, I'll hold your objection in advance while he try to lay some foundation here.
Now, you already testified you live with your sister. Is that a yes?
Yeah.
And were you, do you know how long your sister had been in a relationship with Mr. Buck?
Timeline of their relationship is extremely. I'm not very. Yeah, they've been involved with some.
Sometime months, years, decades.
Months.
So it had been on and off. Was it for months or years?
Been years.
Okay. And during that time, did you personally see how they interacted with each other?
Yes.
And what you saw, were you seeing what to you seemed as though healthy interactions?
No.
Was it, what made you say that you were not seeing healthy interactions?
I'm going to object to the relevance of this line of questioning.
What's relevant?
Well, I think that we approach it. I'm not feeding her what I wanted to say.
I don't even know if we can whisper in here because there's so many. Just
Go over there.
There's so many hands. Back on the record.
I guess before people restart their questioning, is there a ruling from the court on my objection?
Your objection is sustained. You can continue.
Now, do you remember if you told the police that you believed your sister would try to protect Mr. Buck?
Yes.
So you did tell the police that?
Yes.
And is that what you believed at the time?
Yes.
Why did you believe that?
And again, I'm just going to remove my objection, Your Honor. I understand the court's ruling was reserved. I will remove my objections.
Okay, you can continue.
Okay. And just to make the record, that objection was overruled in each of the conversation. So anyway, what was the basis for your belief that she would try to?
Just due to situations beforehand within a relationship in which I believe that.
I can barely hear you.
Oh, I'm sorry. Due to just situations with her ongoing relationship, in which I believe that she is emotionally involved in order to protect father.
So I believe what you said was there have been times in a relationship when she's been, did you say emotionally involved to
I
protect?
believe so.
Okay. And
That's your belief, though. correct?
Yes.
Okay,
Yes, sorry.
but what is it that exactly did you say to the police referencing this?
I'm sorry.
What is it that you said to the police about whether or not she was going to be forthcoming?
I wasn't descriptive as into certain incidents. I just, again, when I stated to the police, again, this is of what I know, as to why I believe in my sister would do that.
I'm asking you to tell me verbatim what you said, though, to the police, because I'm not clear what her statement to the police was.
if you were to, I guess, watch the video, or if you can't make that work to the transcript of what you said, would that refresh your memory as to what exactly you told the police?
I could be the transcript fine.
But would it refresh your memory?
Yes, yes.
Your Honor, I have first witness.
You may.
So did that refresh your memory as to what you said?
Yes.
And would you agree that what is in this transcript is verbatim what you said to the police?
Yes.
Okay, now could you please read what it is you said to the police?
My sister's definitely not going to like explain that. I mean, she's gonna protect him or whatever.
So just make sure, I believe what you said was, my sister is definitely not going to like explain that. I mean, she's gonna protect him or whatever. Is that what you said? And then your testimony was that the basis for that belief was just prior instances in which she seemed to be trying to protect the father of her child. Is that what you said? If I try to recollect what you said previously and I'm misinterpreting it, just let me know, okay? Now, when you were initially on the phone with 911, where was Mr. Buck?
Initially,
Yes, when you first called 911, where was Mr. Buck?
when I first called 911, Mr. Buck was still within the room that my sister was at.
So this was inside of the house?
Yes,
And where in the house were you located?
this is the back of the home.
Is it your sister's bedroom?
Yes.
And did Mr. Buck do anything in regards to this 911 call?
So when I approached what, to see what was going on, that's when I decided to call 911 in hope that he would just leave the premises.
And did you give any reason to believe that he either approved or disapproved of you calling 911?
Yes.
And could you please explain?
So as I was telling him that I was calling 911, that's when he did come out of there and he did tell me not to call. But I told him that I was going to call again for my own safety as well. My son was right there as well. And so as I proceeded towards the street, he continued to follow me as I was on with the dispatcher as I was giving him the request.
And did he do anything to try and prevent you from completing the call?
He did not physically do anything.
Give me 1 second. Now, do you recall telling the police that he tried to grab the phone out of your hands?
No, I didn't.
You do not recall. If you were to look at the police report, would that refresh your memory?
No.
No, it would not refresh your memory. And all of this happened at your house at the address we mentioned earlier. And that house, is it in the city of Lansing, County of Bingham? I have no further questions. Thank you.
Cross-examination.
Good afternoon, ma'am. You are Alita's sister, is that correct? Okay. And you live at the same home? And who all lives at that home?
Myself, my son, my mother, my sister, and my sister.
And was your son home while this was occurring?
Yes.
How old is your son?
17.
Okay. Did you see him at any point during any of these interactions?
No.
Okay. And we just heard a 911 call, and that was a call that you made, is that correct? Okay. And I'm sorry, is that a yes?
Oh, yes, sorry.
And you were able to make that call?
Yes.
And you said that Mr. Buck did absolutely nothing physically to stop you from making that call?
Yes.
And it sounds like you were on call with them for quite some time, for several minutes.
Yes.
And there's a lot of discussion in your direct testimony about what led you to believe certain things. Would you agree with me that those were essentially assumptions that you were making?
Like based on the noises?
Yes.
Yes.
But you never saw Mr. Buck beating your sister, though, is that correct?
Correct. Yes. Or no, I'm sorry. Well, I'm sorry.
Okay,
I'm so sorry.
Okay, let me rephrase.
No, I did not physically see Mr.
Yeah. You never saw Mr. Buck physically beat your sister?
No.
You never saw Mr. Buck kick in a door?
No.
You never saw him smash in a door?
No.
And you had an opportunity to observe your sister that night.
Yes.
And she appeared to be intoxicated to you at all?
No.
Had you been consuming any type of alcohol that night?
Yes.
What had you been consuming?
I had previously been out to a bar with friends and had beers.
So you consumed beers?
Yes.
How many had you consumed?
I can't recall. Okay.
And were these glasses, were these cans of beer? What were they?
Okay.
And what period of time in relation to you arriving home and calling the police? What period of time difference was there between that and you consuming these beers?
Like when I left where I was to as to where when I arrived to the
Yes, when you
about
stopped.
30 minutes.
Okay, so about a half-hour period of time from when you stopped consuming the alcohol and when you arrive back home and end up calling the 911.
I mean, I don't recall when my last drink was that night. So I'm just giving you a time frame as in which the bar was closed and I arrived to
It's a rough approximation.
so
in other
about
words.
30, 45 minutes.
Okay. And prior to your testimony today, have you had an opportunity to speak with the prosecuting attorney in this case?
Have I talked to him?
Yes.
No, I had not talked to him.
Did you have a phone call with the prosecuting attorney in this case sometime prior to testifying here today?
He
Have you spoken at all with your sister since this incident occurred?
Yes.
We talked about what happened.
Yes.
How many times would you say?
Probably within the first 3 days. Oh, I mean, well, even like prior, like coming into this in here tonight or today.
Yes.
Oh, well, probably, I mean, after the incident, maybe 3 days, and then we've been talking about it probably the past 2 days.
Right. Has that been regularly between the two of you that you've been talking about the last couple of days?
As in, like, in detail.
Sure.
I'm not specifically in detail, but just as what. I mean,
Who initiates those conversations about what did or did not happen that night when they occurred?
I don't think I guess we're talking about. I don't understand.
Well, you
I
just
can't
said.
hear you, ma'am.
I'm sorry. I'm not unsure. Could you clarify that for me?
Sure. You just said that you and your sister,
Mhm.
at least in the last couple of days, have had conversations about this incident. Did I hear that correctly?
Well, yes, we're sisters.
Okay. And so my question to you is, who has been initiating those
I feel like
conversations?
it's been equal.
So in other words,
Both of us.
sometime.
Sometimes myself, sometimes her.
Well, we need to create a record here as to what's being said, and so we need to watch about over talking each other, so if you can wait until I finish a
I
question
didn't
before
interrupt.
you interject, so we can make the record, okay?
Yes.
So in other words, and sometimes you initiate those conversations and sometimes she does. Have you talked with her about what her testimony was going to be here today?
No.
Have you spoken with her about what you were going to be saying or not saying here today?
I feel like the only thing I got, yes.
Okay. And what were you saying in regards to that? What were you telling her you were going to say or not say?
I told her that I was going to tell the picture what I recall of that.
Did you say that just in a general term, and did you go into specifics?
No, I didn't go into specifics because we were both there at the scene. I mean, you know what?
Did you come to court here today, or did you come separately?
I drove her.
So you both,
We reside in the same home.
okay, so you both come together.
Yes.
You talk on the way over to court about what either of you would be testifying about.
No.
And I think to say you love your sister,
Yes.
you care about your sister very much.
Yes.
Okay. And am I safe in assuming that you don't like Mr. Buck very well?
I really don't have an opinion.
I didn't hear you.
I don't really have an opinion about him.
Do you dislike or disapprove of Mr. Buck's relationship with your sister?
Yes.
I think that's all the questions I have.
Well, I have a question. When you called 911, were you aware that there was another male in the room?
No, I was not.
You were not aware?
No.
That makes some sense. Explain some things that's going on in this phone call that nobody clarified for me.
Oh, yeah.
Okay, and so when you heard these bangs, you don't know what's going on. You just know it's your sister's room.
Correct. May I further, can I actually describe what kind of made a prior thing that happened leading up to that?
A prior thing that happened?
Well, yes, because when I was in my vehicle, Mr. Buck approached my vehicle, tapping on my car.
Oh, so just prior to that, you knew
Prior
Mr.
to-
Buck was there? You
I
did
did
see
because
it?
he came, yes, he came knocking on my car. I was inside my car.
Oh,
Again,
okay. So
yes.
did you speak with him earlier?
He approached my car, he knocked on my car, he said something as to, I believe what was going, like, what, again, I don't really recall what he said, but he seemed to be upset.
Okay.
As that happened, he then, he left, because I really didn't think about it. Like, I was just like, I sat there, I'm like, okay, I mean, again, their relationship is tumultuous, so I just, it's not
And you're
my
just sitting
business.
in your car? Are you on the
I
phone or
was,
something?
I was on the phone.
Okay.
Yes.
Okay, so he tapped on your phone. He said something that you couldn't quite gather what was being said, but you
Correct.
could tell he was upset.
Yeah, I told you he was upset.
And then you
And
saw
then-
him go towards your sister's.
Yeah, so no, he went back, I think went back to his vehicle.
Oh.
And then again, I just didn't pay no mind because it's not really my business, it's not my relationship. And then all of a sudden I heard that's all, like, literally probably like maybe 2 to 5 minutes after that, that's when I heard the noise, and that's when I heard this.
Okay, so from where you're parked, can you see your sister's door?
I cannot see it, but I'm very close proximity to it.
Okay, so you can hear, but you can't see. Okay.
It's very close in proximity to where the entrance is.
And did he at no time did he put his hands on you?
No, and I believe that's in the police report. He did not physically do anything to me.
Did he threaten you?
No, he did not.
Oh, okay. Redirect.
No, but thank you for helping us.
Thank you.
I have no questions based upon the court's questioning. Thank you.
Okay, this is a frustration order, so you're not to discuss your testimony with any other witness, okay?
Oh, yes, sir.
Thank you.
And I do need to briefly recall.
I can go.
Yes,
You can go, but I'm gonna have to go. grab
but
it.
you can't leave because he's gonna recall the person that drove was here.
Yeah, I know.
This is reindeer games. I'm trying to understand. We might need to approach. Why are you calling her? I'm confused. For what?
Clear that up, when Mr. Marshall gets back.
There we go. Mr. Murphy, yeah, maybe you can approach because I'm not sure why we're recalling a witness.
I
You
think
can have a
that
seat, ma'am. You're
having
still
on the
under
record
oath.
will be- Okay, I apologize. We need to just clear up some confusion. You and I spoke on the phone a weekish ago, is that right?
Yes,
And then you came to my office yesterday evening and we spoke again.
yes,
And then did it come out that I thought I had actually spoken to your sister?
yes,
Okay, when you and I spoke, did you indicate that your sister was blackout drunk the night this happened?
yes.
Okay, and sitting here now, is that your recollection that she was really drunk?
And I'm sorry, Your Honor, just to clarify, there was a couple conversations that were alluded to, and I think we need to clarify if he's talking about the earlier conversation you had with her a week ago or the conversation you had with her yesterday.
When we spoke on the phone a week ago, did you tell me that your sister was blackout drunk at the time? Okay, but we did not discuss that yesterday.
No.
Okay, and I'm sorry about this. As you sit here now, is it your memory that she was drunk at the time?
Yeah.
Okay. And when we spoke on the phone, did you tell me that your sister was never hit?
Yeah.
Okay. And sitting here now, is it your memory that your sister was never hit? Yeah. No further questions.
Any questions for you?
Right from now. The phone conversation you had with the prosecutor, I believe that was on July the 1st, a little over a week ago. Does that sound about right?
Sounds about right, yeah.
Was that a call that you initiated or one was initiated to you from the prosecutor's office?
It was initiated to me. I had missed that call. I called him back.
Okay. And you'd indicated not just that your sister was drunk, but blackout drunk in that conversation. Is that correct?
Yeah.
All right, thank you.
And no redirect. And this time you and your sister are.
Thank you.
Right?
Yes, you can leave. I'm sorry. Thank you so much. At this time, the people rest.
Any defense witnesses?
We'll rely on the evidence presented, Your Honor. Thank you.
All right, I'm not gonna pretend here that this is not a big mess.
It's
Because
a
it is
whole
a
mess.
big mess.
This is
And, if I get my way,
foolery of epic proportion.
yes, and if I get my way, it is going to be the circuit court's mess, not your mess. So getting into that, we right now have 3 felony counts, and I think you're expecting me to say that we can only proceed on one of those felony counts. Well, you are correct. Right now, we are going to move to this counts 2.
Counts what?
2, home invasion third degree, and 3, interference with electronic communication.
I think it needs to be 1, because she said he could come in her house whenever he wanted to.
Well,
It was the second time when she was trying to lock the door that he kicked the door in.
yes, okay, so may I explain my position on count 1?
Okay,
So the entry element, there are 2 options. There's break and enter or enter without permission. And it is clear that he did break and enter because she testified that he broke the door when he was entering.
you mean the second time he entered?
Yes,
Okay, because the way this was charged, the second count was to commit the malicious destruction of a building.
okay, well,
Yeah.
okay, well, there are 2 ways we can do this.
You can argue all you want. I already made up my mind already. I didn't heard enough fools just today on this case. And drunk people have making a whole mess of a 911 dispatch. Major credibility issues. Major. And not saying that I don't think I heard some felonies in there, but I don't know that I heard a home invasion first degree.
Well, I would like to make my argument because I believe you did
Please
hear.
be my guest, make your record.
So the first element, and we are going to say, count 2 is charged as third degree. I guess we can either take the charging language from count 2, move it to count 1, or just change count 2 to first degree. I'm getting the sense that this court probably is not inclined to do either of those things, but I'll make my case. The first element, it's a pick 1, enter without permission, break and enter. The testimony was clear that there was a breaking and entering. And she locked the door.
You gotta be clear, you're talking about the second time, right?
The second entry. The testimony is clear that the second entry, she locked the door after.
Was attempting to lock the door, but then also opened the door while he was kicking it in. What's the testimony?
Yeah,
You see the issue? You see the issue we have here.
It's clear where the credibility issues are. It's clear that she's trying to protect him. That's very clear. But it doesn't matter because he broke the doorway when he entered. So even if there was permission, that's immaterial because there's 2 ways we can get that element. One is entry without permission, one is break and enter. And I showed her the picture, People's One, of a broken door frame, and she confirmed that he broke that door frame when he was entering the house. So that's a break and enter in satisfaction of element 1. Now, I submit to you that it's very clear that the downplaying and the backtracking and the big mess was because she wants to protect him. So the downplaying is what's not credible. Every time she said something that was against his interest was more credible than the downplaying, because what she wants is for him to be able to be a father to her children and for him to not be in prison, which would make it hard for him to be a father to her children. Her sister.
Or it could also be because she was cheating and inciting a situation. It could be twofold. I don't think this is just a situation where she feels like she was minding her business and he came over and exploded. I think she feels like I was cheating, which is why the sister said, "Are you effing crazy?"
You're right. There's multiple reasons.
Yeah. So I think that's why she created a situation that spiraled into a mess, and now she probably feels responsible to try to clean it up some for both maybe him, but more or less maybe for the child. I don't know.
Child, yes, and the child is here. It's a very sweet, adorable child.
I can believe so.
So either way, that's an excellent point. I guarantee she feels like this is her fault because she was screwing some other guy when the father of her kid walks in and sees the 2 of them there. And yeah, that's what set this off. And it's a mess. And messes create crimes, create horrible decisions, create violent felonies. And that's what we have here. And the evidence we have is that he left, she closed and locked the door. And then at that point, we just described as a motive to bust his way back in. Okay, so we have a break and enter, a very messy cluster of a break and enter, but we have that. So we have that first element. Now, second element, someone is lawfully present in the house when maybe I'm going out of order. Another element.
Just give me the jury instruction real quick, please.
Right. The jury instruction is there are so many different ways to piece together a first degree home invasion. Let me get that. think it's in chapter 17.
That's it. Oh. It's under assault, like the home invasion is under assault, that's.
Oh, 25.2A, thank you to our intern Grace. which
Breaking
is
and
six.
entering. Okay, 2A. Wonderful, okay, you can continue.
Okay, so the definition we have here, force must have been used. Even opening a door is enough force, but we have an actual break because the doorway is broken. Second, entered the dwelling. Well, I don't think that all the testimony, the absolute mess of a clustered disaster that is this case, that in order to have any success in the circuit court is going to require some work to clean it up. And I believe that work is possible. I believe that work will be done. All of it points towards he entered the dwelling. And we established that it's a dwelling. It's a house. That's where they live. So we have clear testimony that he did enter the dwelling after he broke. Third, now we have two options. Either intended to commit an offense, we're going to go with the second one. So we don't have to prove the intent, or we can prove when the defendant entered, was present in, or was leaving, committed the offense of. And then there's either, I don't know, there's a reference to the statute. One of the options is an assault. So while he was present in, because the testimony from the witness who was very openly trying to protect Mr. Buck, it was after this second forceful
I don't
entry.
know if she's very openly doing that. She said, she conceded, she said, I wasn't gonna lie, but I'm not doing that.
Right, thank you. I tend to make these sweeping statements that are missing the nuance. It's clear that she has a lot of tugs on her credibility. And I think that she had somewhat of a, you could call it a come to Jesus moment when she thought, you know what, I need to tell the truth. And I think that her saying I was gonna lie at first, just she's a little more credible. And I'm not saying that she is sitting there as perfect. I wish we could, some people, they'll tell a jury, we don't pick our victims at central casting, right? You get people who are messy and are involved in messy situations. That's what brings about these crimes. Now, the assault, the slap in the face, she was very clear. She got around the back. He slapped me in the face. Initially, she tried to imply that it was while she was breaking up the fight. She said, well, I was trying to break up a fight. And she explained it very well. I didn't actually say that it happened while I was breaking up the fight, but clearly I was implying that I was trying to break up the fight. Actually, when this happened, he was not in the room. So we have an assault that occurred after he was present in the dwelling. Fourth, when entered, was present in, or was leaving, another person was lawfully present in the dwelling. Well, we have testimony that when he entered, Alina was lawfully present. And then after he entered, Alicia comes in and she's also lawfully present. So we have this giant mess. We have a circus I just showed you, but when you comb your way through this circus, you do see that we have probable cause of each of the elements of first-degree home invasion. And so I am going to respectfully request that the court find over on a sole felony count of first-degree home invasion. And then the others are misdemeanors, which of course do not require the court to make any specific findings. So I apologize for giving you this circus, and
You didn't pick the case.
that's true. So thank you.
Mr. Austin.
Yeah, thank you, Your Honor. Well, I'm certainly in agreement on one thing. This is a mess. This is a mess of epic proportions, and I am certainly not as confident as the people are that this is a mess that can be properly fixed and sorted out at circuit court to find its way there. I certainly don't share in that optimism. I think one of the things is consistent, and I think certainly that they have an indication that the court is certainly strongly picked up on this, is I don't think they can proceed under a theory that Mr. Buck entered the home without permission. I think the testimony was rather clear that he didn't need permission. He had a sense of continuing permission because his daughter was there. This is something that he did many times before, almost routine for him with no issue. Why this whole debacle started is because Mr. Buck went there to either see Alina and or his daughter like he'd done many, many times before and unexpectedly finds Mr. Frazier there. And that is kind of what is at, I think, the center of this whole circus as it's been described. But I clearly don't think that they can operate under any type of legal theory that Mr. Buck entered without permission. That's going to leave them then with breaking and entering. I don't think it was the testimony of Alina that Mr. Buck kicked in the door. She testified about some force going on there the second time around that we're talking about there, but I think there's also a clear distinction that needs to be made. Are we talking about the doorway, the entry to the house? Or are we talking about another door while he's already in there, such as a bedroom door? Because I think that is an important distinction, because I think in order for him to be charged with home invasion, it would require him to break and enter into the dwelling. Once he is already there lawfully with permission, then I think that is a separate issue if he's attempting to use some type of force to gain entry into another room in the home while he's already in there. So I would ask the court to carefully evaluate that when making a decision on bind over as it relates to any home invasion charge. And I think it also goes without saying that the witnesses here have, I think, severe credibility problems. There was a lot of back and forth between the testimony, a lot of contradictions, a lot of changing the testimony, admitting to saying certain things today under oath that were not true, and then later saying, yes, I was being untruthful on that, but I'm being truthful on this. Under Anderson, the court is the sole determiner of credibility at this stage. I don't know how the court is supposed to properly work through all of that when assessing credibility enough to make a decision on bind over for probable cause to support a bind over on any felony count. The people are essentially saying you should discount any of the testimony that is disfavorable to their legal theories here, because their theory is that the witness is somehow lying or exaggerating or not being as forthcoming against you in order in some way to protect Mr. Buck. But I think the court has a pretty good grasp on that situation and all of that. There may be grounds under the testimony to support maybe a misdemeanor assault and battery or domestic violence charge, but I certainly don't think that they have come anywhere close to meeting their burden of proof on a home invasion charge here, and I would ask the court to not bind over on any home invasion count or any felony counts. Thank you.
A couple things that I want to clear. I do think that the evidence was pretty clear which door that was being referred to. There's this exterior door that goes directly into the bedroom of Alina. I think that Alina was specific, like he left and then I closed the door and started trying to lock it. And then that's when he started trying to come back in. And we did have testimony from Alicia about, well, I'm right by this exterior door and I heard this noise, so I do think that it was clear on that. And as far as credibility goes, I would submit that I think that, I believe that it is reasonable to conclude that Alicia was credible in what she described. It was sort of classic big sister, like what is my, the word she used repeatedly was dumbass. What's my dumbass little sister doing? She's with this guy and then she's sleeping with another man in the house where this guy comes and goes. But there aren't, the attacks we have on her credibility are not as present. And as far as the issues, I already touched on the issues with the source of the issues with Alina's credibility. But at the end of the day, when you look at the elements of this offense, I submit to the court that they haven't satisfied the probable cause basis and would again request.
Today was the date scheduled for a preliminary examination. The burden is squarely upon the prosecution to establish that they have sufficient probable cause that the felonies you've been alleged to have committed were in fact committed, and then that you were the one who actually in fact committed it to a probable cause standard. So this is not trial. They don't have to prove each element beyond a reasonable doubt. They only need to show the court more than mere suspicion that these things took place and that you were the one who took place, or the one who took the action that made it take place. The only person here to determine credibility at this stage is me. So I will do that, and I think we know unequivocally we have some issues there. I also weigh the people's likelihood of success if this matter were to go to trial, if they are likely able to establish your guilt, because that's also my burden today. And so count one, you've been charged with home invasion first degree, alleging that you did break and enter without permission of the dwelling at 714 Park, and while entering, present in, or exiting, did commit an assault, and while entering, present in, or exiting the dwelling, Alina Mata and Dwayne Fraser were lawfully present therein. Count two has been charged as home invasion third degree. It says that on or about June 4th, that again, 714 Park Street, you did break and enter, or did enter without permission in dwelling located at 714 Park Street, while entering, present in, or exiting the dwelling, did commit malicious destruction of a building less than 200 and domestic violence, a misdemeanor contrary to MCL 750.11A4. Count three, the other felony is interfering with electronic communications. And says that on about June 4th, you did willfully or maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an unauthorized communication by or through the telephone or telephone line. We had testimony today, both from Ms. Alina Mata, which is the mother of the defendant's child. They've been in a relationship, she said, for approximately 5 years. She was able to obviously positively identify the defendant in court today. She stated that on the date and time in question, they were present at, well, she was present at the home of 714 Park Street. She said that was her mother's home, but that she also lives there. And she said that prior to that time, there had been a couple of phone calls back and forth between her and the defendant, but the defendant didn't answer the phone. She specifically testified that in the home at that time was her, this person named Dwayne Fraser, her child, her sister's child, and her mother. And she was not aware of her sister being there at the time of at least the onset of this incident. She said, based on how the house is set or laid out, and where her bedroom is located, she has this access from the direct outside through a door to her bedroom. She said that the defendant did at that date and time enter into her bedroom, and he walks in, she says, as he always walks in. She testified that he has the freedom to come and go. That was her testimony. So based on that alone, and there was nothing brought out even on today's record that would have caused the court to believe that at some point, even during that time, that she revoked that privilege. That's not even how she laid out the second instance of him coming. She, although albeit, I think that there is some tugs on her as to how she can be credible, testified the second time. She said that the defendant came in, I guess he fought with the Mr. Dwayne Fraser, and then he left through the same door. She then testified that he returned and that he was pushing on the door. And she said at the same time or simultaneously, she was attempting or beginning to lock the door, but then also going to open the door to let him back in. So again, he had access, even based on that testimony, for him to come on in. Home invasion 1 is a specific intent. And so I would have to believe that he broke specifically with the intent to commit either the domestic violence, or that he broke in specifically with the intent to break the door. I don't believe that he was trying to break the door. I think that as he's pushing the door back open, and she was, as she said, pushing the door closed, but then going to open it, which obviously caused great confusion. It's causing great confusion for me, legally trained individual. It's going to cause great confusion for a jury. I don't believe moving forward on count one is justified based on the way the elements are played out or the testimony was played out and the credibility issues. Because if from the time this incident occurred a month ago to now, there's been these tugs on Ms. Mata's part that affected her credibility, I don't think her story is going to get even more credible. I think it's going to become less credible between now and then. And even as we stand here now, between her story, her and her sister's story, and even playing the video because of the audio, that audio doesn't make anything better. It actually just even heightens how ridiculous and confusing and chaotic this situation was. And the person calling the dispatcher, not even completely blows the dispatcher off, doesn't even give accurate information, states that this person is beating her sister's ass and never even witnessed any such thing. And so, no, I think the way that count two was originally drafted is appropriate, and I do this probable cause as to count two. I'm gonna bind count two over as drafted to the circuit court. Count three is dismissed. Count one is dismissed, and the misdemeanors, although we have sufficient testimony, I think at this point that at least count six should be dismissed because she said he never touched her. How can we move forward on a misdemeanor of assault and battery with Alicia? But that's for you all to figure out later. But she said it, that's why I specifically asked her. There's a lot of lying going on back then and a lot of lying that's still going on. And so this is a terrible case.
Your Honor, actually, the people would like to dismiss count six. I apologize.
Okay, count six will also be dismissed. I believe that obviously the others are consistent with whatever we can make out of this situation to be flushed out over at the circuit court. So again, count two and the remaining misdemeanor counts will go over to the circuit court. Find over date is the 22nd of July. That's the date the circuit court's receiving this file, not a court date for you, Mr. Buck. You understand that? Your next court date, Mr. Austin will be made aware of that and he will remain in contact with you. See, only being held on this or something else.
Being held on a probation violation file, Your Honor, that was triggered from this. That's pending with Judge Stokes. But we're hoping to resolve that at least sometime soon. I would just ask, based upon the most serious count being dismissed here today, if the court would consider granting Mr. Buck some relief, either in the form or the amount of the bond.
Mr. Marshall.
I think that the evidence that the court heard today provides it for with a sufficient basis to make a decision on.
Yeah, he's obviously got other issues pending over at the circuit court because, albeit, I believe if this circumstance is triggered by or provoked, I should say, by the behavior of having your door unlocked while you're in there screwing somebody else and having open access to this for him to come in and see it. And then calling him, it was like, what in the world was going on? I have no clue what's going on. Nonetheless, I don't believe is a threat that rises to the level of a $20,000 cash surety bond on this. I will make sure you're aware that you are not going to contact directly or indirectly with her unless you have your third party contact regarding the minor child. And that's only because the magistrate already gave you that. I normally don't even allow that unless there's a family court order because that's typically how it starts. But the magistrate already allows you to have that so you can have access to talk about or deal with your child. So I'll continue that. I will amend the bond to 2,010% with GPS tether so that when in or if you get your matter resolved at circuit court, there's a bond that you could post and return to work so that you can provide for your child. Any additional matters for today's session?
Yes, Ron, I just would like to just make a record of one thing. I guess I disagree with the court's articulation of one of the elements of first degree home invasion. I just want to make a record of that.
Which
MCL.
element, the specific intent part?
The specific intent part.
It says it right here. This is a specific intent crime. It says it in the jury instruction.
Well, I just set MCL 750.11A has, and I agree, there are specific intent components to it.
No, it's not, that it doesn't say there are specific intent components to this crime. The jury instruction specifically states this is a specific intent crime.
Well, the jury instruction is not the law, and I just would like to get into what the statute.
But
says.
I'm not talking about the law. I'm talking about what would you, I also have to weigh your likelihood of success at trial if this were to go to a jury trial. They would need to use these elements in order to prove beyond a reasonable doubt.
No, and I'm not trying to get you to change your mind. I just would like to have a record.
Oh, I'm not gonna
of
change
objection. I would never dream of.
Yeah,
trying to-
I'm not.
Yeah, I'm not insane. I'm not going to try to make
You
you
don't,
change
you
your mind.
have no, you don't even have a single credible witness.
Okay. 750.1110A, section 2. It has a first half, a person who breaks and enters with intent to do yada, yada, yada. Then there's a disjunctive or a person who breaks and enters and actually does XYZ thing. So we don't need to prove a certain intent while breaking and entering. And I just wanted to make a record
Right,
of that.
I appreciate where you're going. I believe though, the elements that are laid out are exactly what happened in count 2, which is what happened. He broke and entered and broke the door. That was what you charged as count 2. Any other questions?
Nothing else from people.
Not on that issue, Your Honor.
Yes,
Just before we go off the record, there is a brief thing that I want to make a record of just
On
for
this?
clarity purposes.
Okay,
Yes, it had to do with the whole recalling of the
Of the-
complaining witness,
okay.
because what triggered my cross-examination of Alicia was I had received a Brady email from Mr. Marchmia who had stated essentially that he had had a conversation with her, the sister, and said the complaining witness was blackout drunk and was never hit by Mr. Buck. So that's why I asked those questions, was puzzled when I got those answers, and had a conversation with Mr. Marchmita. Now, I'm not saying, he was certainly, I think, doing his best at the time to live up to the Brady obligation. He was just mixed up as to who he was
It's
speaking
easy.
to on the phone.
I think
So
the
it's
names are
nothing-
very, I mean, it's easy. They
If I
look
can
alike.
And so I just want to make it clear that
Got
I'm not saying he did anything intentionally wrong or anything of that sort, but that's what led to my puzzling questioning of the sister,
Right.
because I thought that's who it was referencing to.
I
And that's
understand.
what led to the recall, so we could clarify that for the record. He didn't do anything intentionally wrong. It was just a mistake that led to me questioning the wrong witness. That's all. And I just want
Just to clarify, I called the two of them consecutively and I left them both voicemails and I called Alicia second. And then immediately after I left the voicemail, I got a call back and then she says, "Oh, you just called me." And then I thought I was talking to Alicia. And I was not, I was talking to Alina.
Got it. Well, I'm glad we were able to work that out.
We worked something out.
Yeah, best wishes to all of you all on this matter. It's a mess.
Happy Friday.
That's it.
Thank you. You still have
you have any questions right now?
No, Your Honor.
It's that paperwork for you to sign.
This is just certifying the understanding of the right things and-
Thank you. Okay, so the bonds on these, I have like 300 cash surety on both. Are we addressing bond today?
People have nothing on bond, Your Honor.
We will not be addressing it today, Your Honor. We may,
I didn't hear.
will not be addressing.
Oh, okay. Any additional matters for the record?
Nothing from the people.
No, Your Honor.
You're all set. That's it.
All
Thank
right.
you.
So here we're losing Mertens now.
What?
Yeah, she got a job with the AG.
Oh, for nonstop.